The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Is Ms. Bateman there? I don't see her on the screen.
Hi, Your Honor. Yes, I'm here.
Oh, good. Good morning. And I would ask counsel, if you're not on the first case or your case, ask that you would turn off your video feed. Thank you so much. Ms. Bateman, you may proceed.
Thank you, Your Honor, and may it please the court. Lauren Bateman for petitioner appellant Gary Wall. The rule this court announced in Lanier applies to Mr. Wall's case, and neither Wolf nor Teague say otherwise. Wolf never limited federal habeas review. It's a Section 1983 case that limits Section 1983 relief. Teague is the case that governs habeas retroactivity questions. And Teague bars retroactivity only for habeas courts reviewing final criminal judgments. It has nothing to say about prison administrative decisions that no court has examined, let alone approved. I will address Teague and Wolf in turn. First, Teague is no bar to the retroactivity of Lanier. The general rule is that a court applies the law as it exists at the time it resolves a case or controversy. Teague carved out a limited exception to that general rule when it held, and here I quote Teague's holding, quote, new constitutional rules of criminal procedure will not be applicable to those cases which have become final before the new rules are announced, end quote. And the language of that holding illustrates why Teague is inapplicable here. This is not a criminal case. It's a decision by a prison administrator. And the case has not become final. Indeed, this litigation is the very first time a court has considered Mr. Wall's constitutional claims on the merits. That makes it quite unlike the type of case that Teague describes, where a state court has rendered a final criminal judgment and all appeals have been exhausted. The rationale of Teague
if that's so, how do we get jurisdiction? I mean, this is habeas, and we're a collateral review. Our authority is for collateral review, and you're making it sound like we're directly reviewing the state administrative agency. That's a peculiar circumstance, isn't it?
I don't think so, Your Honor. You are absolutely correct that this court is sitting in habeas on collateral review, but it reviews as though it were reviewing the issue on direct appeal in a circumstance where there is no final judicial pronouncement on the merits of the claim. So it's reviewing the case as though it were on direct review because the Virginia Supreme Court declined to issue an opinion on the merits.
Counsel, would you apply the same rule? I'm not sure why that matters, right? We often face criminal cases where the state court declines or does not issue a decision on the merits. And that obviously affects the standard of review we apply in giving deference or not under D, but it doesn't affect the Teague rule, right? The lack of a decision on the merits by the state's highest court doesn't affect Teague. It only affects our review under the D deference provision, right?
That is correct, Your Honor, but the lack of final judgment speaks to the rationale of Teague. So the Teague court was animated by, in part, the concern that.
Let me back, just make sure I understand. But the point is, you just were suggesting the lack of a decision on the merits makes this case different. But the lack of a decision on the merits is actually quite common in a criminal context, where for one reason or another, the state court doesn't issue a decision on the merits. And either that's a procedural default or it doesn't get deference that it would normally get, but it doesn't ever change the Teague application, right? It just affects the degree of deference we give the state court's decision.
That may be the case, Your Honor, but here there's no state court decision to which deference would be owed because no court has.
But that's exactly the example in the criminal context, right? Where the state court does not issue a decision on the merits, but the claim is otherwise exhausted, Teague applies, but subsection D deference does not apply. Right. And so it strikes me that that's the same situation we have here. There's not a decision on the merits. And so we don't give deference to that decision under D, but Teague, which interprets the statute 2254, applies no different here.
But counsel, in your argument a little bit further, that Teague doesn't apply because it's not criminal and there's no decision made, so it's no deference. But even further, there's no adequate remedy under the state. And that's one of the aspects of 2254. There's no state remedy. It's not adequate. It's not just it's not on the merits, but there's no remedy. Virginia said, we don't have jurisdiction. So Judge Richardson makes a great point. It's not just because it's not on the merits, but Teague is because it's not criminal and there's no deference because there's no decision, but it's not because it's not a merit decision. It's just they basically punted, said we don't have jurisdiction to even hear it. So that means the state court, a federal court would have to wait and say, well, we can't hear it. And I think that part of the Judge Nehemiah's good question, that is, what do we do to jurisdictions? Because that's what the great writ is for. When the state won't answer, surrender the body and has no adequate remedy. And that's what we have here. Isn't that your argument, would be your argument?
That's precisely right, Your Honor. And I think the rationale of Teague reveals why that is correct, precisely correct, because the Teague court was animated by two concerns. One was comedy with state courts and refraining from undermining the integrity of state court processes. But as you observed, that is not implicated here because there's no state court process to undermine. The state court didn't issue a decision on the merits. But also the Teague court was concerned with the social and judicial costs of relitigating final convictions. And here there's no criminal conviction at all. And the attendant costs of relitigating Mr. Wall's case alongside similarly situated cases is exceedingly small because Lanier can only apply retroactively to a slim category of cases. There's also a practical reason not to recast Teague in the way that the Commonwealth seeks, and that's that it would represent a radical expansion of non-retroactivity doctrine and a significant departure from the status quo. Prison disciplinary decisions would be effectively unreviewable, except in the exceedingly rare case described in Lambrix v. Singletary, where the constitutional violation at issue is indistinguishable from one described in the past precedent. That sweeping preclusion of prisoner constitutional claims is, as the Supreme Court has stated, plainly untenable because there's no iron curtain drawn between the Constitution and the prisons of this country.
Counsel, can I ask a slightly different question on a different angle? We talked a little bit about the state Supreme Court, and they relied on the Carroll versus Johnson decision and said we lack jurisdiction over the prison disciplinary decision. Would it make a difference to your argument if that is incorrect? So in other words, if Carroll versus Johnson actually does permit the state courts, be it the circuit court or the Supreme Court, to review prison disciplinary hearings under state habeas?
It would not make a difference, Your Honor. And the reason why I say that is that the question before this court now is whether Mr. Wall is entitled to a court, any court, reviewing his constitutional claims. Had the Virginia Supreme Court decided differently, of course, we would be in a different situation. Had it issued an opinion on the merits, EDPA deference might apply to that opinion. But here, the only question is whether Mr. Wall is entitled to have any court look at his claims.
Well, but the point is that, you know, if the state system permits review, and, you know, the state Supreme Court just made a mistake in not accepting jurisdiction, then in fact, we don't have the situation that you're describing, right? We have a situation like we see all the time where there's not a decision on the merits, right? But it was properly exhausted. And so you don't get deference, but Teague still applies, right? And so I guess what I'm getting at is if the proper reading of Carroll versus Johnson is that this type of claim is indeed reviewable under state habeas, then we're in the same boat that we were before, no?
I don't think so, Your Honor. And the reason I say that is because that would subvert the underlying rationale of Teague, which is deference to state court decisions. So if this court were to—
That would be true in a criminal case where there was not a decision on the merits either, right? I mean, so in a criminal case where there's not a decision on the merits, Teague applies, but you don't get D deference, right? And so whatever we want to talk about the rationale, the interpretation of 2254, which is what Teague is doing, doesn't change because there's not a decision on the merits. I understand your desire to go back to the failure to have a decision on the merits, right? Because I understand why you want to go there, but it doesn't get you anywhere, I don't believe.
Oh, well, Your Honor, I think Teague's the other element of Teague's holding is that it requires for non-retroactivity to apply, it requires there to be a final criminal conviction. So your examples stemming from a final criminal conviction, I don't think speak to this particular circumstance where there hasn't been a final criminal conviction. And so the rule that would apply is just the one that the Supreme Court articulated in Griffith v. Kentucky, which is simply apply the law as it is at the time the court reviews the decision. The Commonwealth's other argument is that Wolf bars the application of Lanier to this case. But the Wolf Court was very clear that it intended only to limit the scope of relief as to 1983 cases where incarcerated people sought damages or an injunction. Wolf did not limit the scope of habeas relief for cases in which the fact of confinement is challenged and the remedy sought is restoration of good time credits. But if Wolf ever spoke to the retroactivity of habeas relief, it certainly doesn't as of 1989 because Teague is the case that governs that question. And there are two ways we know that to be true. The first is doctrinal. Teague's lengthy discussion of the issues with the link letter standard for retroactivity, i.e. the regime that Teague displaced, demonstrates that the court intended to put a halt to exactly the kind of retroactivity analysis we see in Wolf. Wolf's retroactivity analysis, which balances the gravity of the right at stake with the practical difficulties of making a particular form of relief retroactive, is the exact kind of rootless, free-ranging balancing approach that the Supreme Court found so disturbing in Linkletter because it led to disparate results for similarly situated individuals. And the second reason we know that Teague, not Wolf, governs questions of retroactivity in habeas cases is empirical. The Commonwealth has not identified, and we have not found, a single case in this circuit or otherwise where a court applied Wolf's retroactivity analysis in the habeas context post-Teague.
But counsel, isn't the reason for that because Teague is itself interpreting the statute, right? What the rationales are what they are, but Teague said the statute 2254, which you are proceeding under, means that you do not look at, later adopted procedural or substantive rules, right? And that's changed a little bit recently with the procedural pieces. But the procedural and substantive rules that are later don't get looked at under 2254, right? Just the statutory definition, right? So how do we look at that? I mean, that's why we're not applying Wolf, is because you're proceeding under 2254 and Teague interpreted 2254.
That is correct, Your Honor. Teague interpreted the scope of availability of habeas relief. That is correct, under 2254.
Right, but in doing so, it interpreted the statute, right? It's not interpreting the Great Writ, right? It's interpreting Section 2254, and it divines this rule that we now call the Teague rule, right? But from the statute, it's a statutory interpretation case, right?
I don't think so, Your Honor. I don't think Teague is a straight up statutory interpretation case. Rather, it tailored the scope of habeas relief based on concerns that are found outside of the statute, namely comity to state courts and the practical considerations of relitigating final criminal convictions.
And there were concerns that were in the context of criminal cases and convictions, were they not?
That is precisely correct. And the last argument that we would like to advance is that even if this court were to stand in equipoise on the question of retroactivity, it should simply reach the same conclusion as the Lanier court did. As the Lanier court observed, its rulings stemmed from binding precedent in this court and in the Supreme Court, and Lanier itself applied to events that had already occurred. And finally, this court has already afforded other litigants exactly the relief that Mr. Wall seeks. Both in McWilliams v. Sod and Hawkins v. Coakley, this court applied Lanier's principles to habeas petitions denied in the district court before Lanier was announced. This court should do the same here. If there are no further questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you, Ms. Bateman.
Thank you.
Ms. Samuels, you may proceed.
Good morning, Your Honors. May it please the court.
Yes.
Jessica Samuels for respondent. In 2015, petitioner Mr. Wall was charged with and found guilty of assaulting 2 corrections officers at Red Onion State Prison in 2015. In this case, Mr. Wall seeks federal habeas relief based on the court's recent decision in Lanier v. Wilson regarding access to video evidence. But Lanier was not decided until 2019, long after Mr. Wall's disciplinary convictions became final and several months after the district court had dismissed Mr. Wall's habeas petition. Despite this mismatch in timing, Mr. Wall asks that the principles applied in Lanier be applied here retroactively in federal habeas to vacate his disciplinary convictions. While it is far from clear that Mr. Wall would actually prevail on the merits, primarily because the hearings officers have since seen the video at issue and testified under oath in a separate case that it would not have made a difference, this court need not reach those merits issues here. As a threshold matter, Lanier may not be applied retroactively to Mr. Wall's habeas petition under 2 separate lines of Supreme Court precedent, one grounded in Wolf and the other in Teague. Both Wolf and Teague adopt a strong policy against retroactivity of new procedural rules, and each precedent provides an independent basis on which this court should affirm the dismissal of Mr. Wall's petition below. I'd like to begin with the Wolf holding, the Supreme Court's non-retroactivity holding here, because our view is that provides a sufficient basis for this court to affirm. In Wolf, the court considered what minimum procedures the Due Process Clause requires for prison disciplinary proceedings. And in doing so, the court specifically reversed the Eighth Circuit's holding that the newly announced due process requirements applied retroactively to disciplinary proceedings that had already taken place at the time the court issued its decision. The court reached its non-retroactivity conclusion by looking to precedent regarding parole revocation proceedings and reasoning that if those standards only applied in the future, which was already a given at that time, given prior precedent, then the same had to be true for the prison disciplinary proceedings at issue in the Wolf case. That conclusion was also informed by the great weight that must be given to the significant impact a retroactivity ruling would have on the administration of prisons and the reliance prison officials placed in good faith on prior law not requiring such procedures. The year after Wolf, the Supreme Court confirmed that it meant what it said about retroactivity in prison disciplinary proceedings. In Cox v. Cook, the Supreme Court reversed a decision of this court, allowing a suit to proceed against Virginia prison officials that challenged disciplinary proceedings under the standards outlined in Wolf. But as the court noted, those proceedings predated Wolf, and the Supreme Court accordingly reversed because the Wolf decision was expressly not retroactive. The same is true here, and the Seventh Circuit's decision in Sanchez has already so held. Sanchez was also a federal habeas case where the petitioner sought retroactive application of a decision that established standards for prison disciplinary adjudications. Applying Wolf, the Seventh Circuit declined to apply the new rule retroactively. That principle from Wolf resolves this case, and Mr. Wall has not shown otherwise. It's true, as discussed this morning, that Wolf was not a habeas case, but that's a question of remedy rather than substantive law, and is also a feature of the fact that the decision predated the stricter rules we have today under Heck v. Humphrey that police the line between Section 1983 and habeas relief. Even so, regardless of whether a litigant seeks damages or injunctive relief restoring good time, the court in Wolf was still evaluating the same core question we're presented with here, which is what the Due Process Clause requires, and specifically to this case, whether that holding should apply retroactively in the prison disciplinary context. Wolf also does not appear to adopt or authorize the type of balancing that petitioner claims. Rather than suggesting some sort of ad hoc inquiry balancing burdens and rules, Wolf's non-retroactivity holding, in our view, is more of a bright line rule that changes of equal or lesser scope to what is required of prison officials in prison disciplinary hearings will not be applied retroactively. And so for all of those reasons, Your Honors, we think if you would prefer not to get into Teague, that Wolf is an independent and separate basis that decides this case, and that Sanchez has already done so, and that this court could follow suit here.
And you recognize Wolf, of course, is a 1983 case.
Yes, Your Honor, it was
and,
a 19...
and in Wolf, they were concerned about the damage aspects of these 1983 cases, correct?
Yes, Your Honor, Wolf was a 1983 case.
And they were concerned about the damages aspect of those cases that might come up in terms of these civil claims for damages, in terms of whether or not, did it not?
I agree they were concerned because that was the remedy that allowed the court to proceed there, because Precer v. Rodriguez had already held that case seeking relief couldn't be held and couldn't proceed in 1983. But I don't agree, Your Honor, that the only issue the court was weighing in Wolf was a damages relief in a Section 1983 case. The non-retroactivity holding specifically quotes the great weight that should be given to the significant impact a retroactivity ruling would have on the administration of prisons, and also the good faith reliance of prison officials. And so I think that there the court is looking at more than just necessarily litigation or money or the state coffers or damages. I think there the court was specifically looking at this question about whether the procedural due process protections that were announced, whether it's those can be applied retroactively, given that state prison officials had proceeded up to that point under fully consistent federal law. So I do still...
Go ahead, I don't cut you off, go ahead.
I just think that there was a lot at play in Wolf, and I think the fact that it came before the strict line that we have today about Section 1983 and habeas, it shows that that doesn't take it fully off the table here. It's still applicable, because I think under the precedent that applies today, the ruling would have been that that had to be in habeas because a finding for the prisoner would have undermined the prison disciplinary conviction. So I think that it's a feature of when Wolf was decided, but I don't think it cuts against the non-retroactivity holding.
So Ms. Sanders, since you opened the door this way by your argument, you talked about how I guess we should feel sanguine, that you said some hearing officers have looked at the tape and they're satisfied that what it shows and didn't show, right? We should feel sanguine about that in this case?
I agree with that, Your Honor, but I don't think you need to reach that issue here. I think it just shows that if the court were to reach a retroactivity holding here, that the best Mr. Wall could do is a remand, because there are harmless error issues that would need to be analyzed. And Lanier specifically said that harmless error applies to the new rule that it announced. And I think we would have a very strong harmless error case here, as evidenced by that other litigation that we've referenced this morning. And I also think that the...
Oh, really? Was it the criminal case was dropped against him, was it not? Wasn't even brought.
He never faced criminal charges. That's correct.
It was dropped by the prosecutor after looking at the tape, wasn't it?
That's my understanding. It was nolli prosequid, yes.
Right. And all he was asking for is that, saying, look at the tape. How does that impact? I mean, you're taking the time for a hearing. You said it must be relevant because you allowed someone else who looked at it to give an examination of their interpretation. So how how does that comport with any sense of justice? I mean, since you opened it up, how would that? How does that?
Your Honor, I think at the time that the hearing fully complied with the rules and the federal procedural due process protections that existed in 2015.
Rules? You mean you take 9 months from somebody and all you have to do is look at the tape that's in your control?
At the time, Your Honor, the Wolf.
I'm not talking about the time. I'm talking about the Commonwealth. I'm a Virginian. You know, we are proud of Thomas Jefferson and all those ideals and constant principles. I'm talking about the idea, a sense of fairness and decency. Why would you play it if it's so clearly inculpating? Why just play it? I mean, well, you don't know, do you? I mean, I'm just squandering about this case. Why? I mean, it's kind of disappointing in the sense that somebody wouldn't say, well, let's play it.
There were several reasons that in 2015, at the time of these adjudications, that the default rule in the Department of Corrections was not that all prisoners could have access to all videotapes whenever they asked for it. There were
I agree. There's circumstances where absolutely, that's not this case. You're right, there's some cases may implicate informants, you don't want to know, but this is where he's charged with assaulting 2 officers, not involving other inmates. We know who the parties are. It's Mr. Wall and allegedly what happened between 2 officers. So you're not expanding the scope or bringing in people who may be informants. You're just trying to bring in truth. And that truth cuts one way or the other. Either it hurts him or it helps him. But truth, in sense, I'm just, can you help me with that? How does the Commonwealth take a position like that?
Your Honor, an example in this case is that much of what happened here happened in a blind spot in the video. And that's just one example of a security reason that providing video across the board may not be a serve penological interest. But more importantly, Your Honor, I think this view
that was never raised in the record, you know that.
That's right, Your Honor, but it's because
the only thing that was raised in the record at all. None of the penological reasons, none of it. You gotta argue the record at least. And I'll let you go, but I'm just, I don't know, just a sense of justice and decency. To take 9 months away from a person, I mean, 9 months of the time in prison could be very dangerous. I mean, it's a big difference. I'll let you go. I guess you've answered the best you can. Thank you.
I agree, Your Honor, that the 9 months was a penalty, a serious penalty. And I think that the questions we've been discussing are framed in the context of assuming in hindsight that prison disciplinary officials had the benefit of the linear decision. And I'll note that the Tyler v. Hooks decision by this court specifically held that Lanier broke new ground. And I think that whether you're looking at it through Wolf or through Teague, which I'd be happy to talk about habeas doctrine and the many features of that, but whether you're looking at through either of those lenses, that by breaking new ground about what federal law requires in Lanier, that then looking back at everything that's happened through that prism would be a retroactive application of a new procedural rule.
But what's the answer the counsel said? We've already done it in the Fourth Circuit, have we not? We've looked at cases that was retroactively applied. And I'm sure their cases probably were not as direct as this. This is about as clear cut as you can get. I could see if Lanier had somebody's using the application. Well, I want to see whether or not, somebody tossed my cell when I wasn't there, or somebody did something on the yard and I want to get video. That aspect of whatever. But here, this is just a simple charge, not simple charge. It's an important charge, obviously. But it's a very discreet, not simple, but a discreet request that I would think that's just common sense and fairness with that. And we've already done so. So I think because our court saw the fairness of that, that's why we did so.
I don't agree, Your Honor, that the Lanier has already applied retroactively.
So you disagree with counsel? Well, when counsel can do that, maybe she can give us the basis for saying that.
I can guess. Let me predict it since I don't get back up. But my guess is that Lanier, it did remand. Lanier reached its holding and then remanded for further proceedings rather than engaging in a retroactivity analysis right in that case. But I think that what that means is on remand, in my view, the district court would be faced with the retroactivity question. And my recollection is that I believe on remand, Lanier settled. I know there haven't been any further substantive decisions in that case. But I think what that means, that doesn't necessarily mean anything here because Teague is not jurisdictional and has to be raised by the government. And so they didn't raise it before the court in Lanier. I don't know if they would have raised it on remand, but I don't think it's true that Lanier has already been applied retroactively. And I think if the court were to reach that holding here, it would break significant new ground as a matter of both statutory and constitutional law.
Counsel, can I change the subject for you for just a few minutes? Your colleague on the other side suggests that there's no state remedy, and in essence saying that state habeas review does not permit considering prison disciplinary hearings that lose 9 months, as we've talked about. You seem to suggest in your brief that's not true, that Carroll versus Johnson, in fact, changed the law in Virginia. And in fact, you can receive state habeas review in either the circuit court or the Supreme Court. It's up to the litigant to decide which of those to follow. And indeed, quite a few district courts in Virginia have so held. First, is that true? And if so, can you help me understand what happened with the Supreme Court in this particular case? Does the Commonwealth contend that was a mistake, or do you have another explanation for the Supreme Court's decision in this particular case?
I think Your Honor's interpretation of Carroll is correct. Carroll did away with the immediate release requirement, and in doing so held that any holding that may eventually affect a future release, in other words, the duration of a confinement, is cognizable on state habeas. I think that is the correct reading of Carroll. I think in terms of the Supreme Court's decision here, I'm not sure what happened. I think that it could have come out the other way. And I think this isn't the first time in habeas that we might see a state court reaching a decision under state law that maybe we don't agree with now. I don't have another explanation for the Supreme Court's ruling in Carroll, but I do think it's important to note that—
Let me ask you about that does that mean that in this case, Wall could still raise, which has been affected by the ruling here? In other words, what is the nature of this?
The holding.
Well, I understand that, but it seems sort of peculiar. It's sort of a notion that it doesn't arise yet because this is a future event, right?
I think that's maybe one way to read what the Supreme Court of Virginia did in Mr. Wall's decision here. I don't know that that's entirely consistent with the Carroll precedent that was announced. Again, Carroll itself made habeas more available, not less available. But I'd like to just set all of that aside, Your Honors, because I don't think that it affects the analysis here, which is whether there's a state court adjudication on the merits, more generally, whether a state court even allows habeas relief or allows for direct review of these types of decisions, that can't affect the federal court's habeas authority under 2254. As Judge Richardson noted, Teague is a statutory interpretation case. And so this idea that as a general matter, whether states provide an adequate remedy, it's not even remedy, it's whether they provide review. And more specific to this case, the idea that whether states correctly apply that law or not, the outcomes of those two inquiries can't then be read to expand and contract the federal court's habeas authority, because what you would end up with is a different reading of 2254, not just in every single state, but in every single case based on whether a state applied its rules of appellate procedure correctly or incorrectly. And I just don't think that's a tenable reading of 2254 or what Teague is doing. And to be very clear, Your Honor, that—
Counsel, you already have that. The whole nature of 2254 is based upon the state's laws. That's how federalism works to that extent of it. We look at what the state has done, we give deference, and The deference is based on that court ruling its law. And obviously, a case in another state is going to be based on that state's law. So that difference exists anyway. There's no uniformity is reached by taking the view you're talking about in terms of Teague's impact there.
I have two responses to.
Go ahead.
I'm sorry, Your Honor. I have two responses to that. The first is this is not a deference case, as Judge Richardson noted. This is not a 2254D case because there wasn't an adjudication on the merits.
I know that, but you suggested this will cause a lack of uniformity and a difference in terms of how we may apply 2254 based on the difference in state laws. But isn't that the framework for it anyway?
Your Honor, I was making a slightly different point, which that there can't be a difference. I'm not talking about a difference in uniformity of outcomes. I'm talking about a difference in federal court habeas jurisdiction in terms of whether the cases can even get into court under 2254. And I think that the way that that Teague interpreted that statute did so, saying that when federal courts sit in habeas, it's not a freewheeling constitutional review, it's a limited scope remedy, and that remedy doesn't allow for retroactively applying new procedural rules.
So you're saying exhaustion does not vary from state to state? How the case is exhausted doesn't vary at all based on state criminal proceedings and procedures that are available?
I see my time has expired. May I answer, Your Honor?
Yes, you may.
I do agree that exhaustion varies from state to state, but that's just not what's at issue here. The issue here is that under petitioner's theory, when federal courts would be statutorily authorized to grant habeas relief would vary based on whether a state provides, say, direct review, or how it applies habeas, or how a state court applies those procedures. And an interpretation of a federal court's authority can't depend on exogenous factors like that. I don't think that there's any support for that kind of reading.
Okay, thank you, counsel. Appreciate it.
Thank you. Thank you, Your Honors. We'd ask you to affirm.
Yes. Ms. Bateman, you have a few moments left.
Thank you, Your Honor. I'd like to start with something that the Commonwealth and Mr. Wall agree upon, and that's that if there isn't a retroactivity bar, the question of harmlessness, whether the video could have made a difference in Mr. Wall's disciplinary hearings, is one that can only be resolved on remand. So, Wolf. The Commonwealth never directly addresses the argument that Wolf is a 1983 case that limits 1983 relief. This court need only look to the question presented in Wolf to see that that's true. And the question presented in Wolf was whether under Prizer v. Rodriguez, the validity of the procedures for depriving prisoners of good time credits may be considered in a civil rights suit brought under 42 USC section 1983. It has nothing to do with the availability of habeas relief. But even so—
No, but it does have to do with the principles that both Teague and Wolf addressed, is how do we apply rules that have changed? In other words, the law constantly is changing. It's changing statutorily, it's changing rules, it's changing with decisions. And we have to have some rules to create finality. And both Wolf and Teague basically establish principles of law that direct us how to assess retroactivity. Otherwise, everybody in prison is just continuously bringing habeas proceedings as each new rule and each new case comes down. I mean, even this case, it's not dependent on the state. It would be a universal rule that we can now review procedural rules that are not retroactive. And this rule was established, Lanier was established 4 years after this proceeding. And so now you wish us to apply a rule that was established 4 years after the final disposition in prison to that. What prevents the guy that's been in there 10 years from raising it? And in other words, there comes a practicality notion that all these cases address is the law is dynamic. And it's not a question of justice. Generally, we addressed the justice issue in Lanier. The question is, as we change the law and correct things, how far back do we go and uncover everything that's been done? when those proceedings were at the time fully just and in compliance with law. This 4-year differential is fairly significant, isn't it?
Well, Your Honor is exactly correct that Wolf does deal with the potential retroactive effect of rules. It is not the case, as the Commonwealth seeks to convey now, that Wolf created a bright line rule that no procedural rules can ever apply retroactively. In fact, Wolf has a balancing
Of course
test.
not, but this is part of the dialogue. I mean, we have to assess where the Supreme Court was in Wolf, and they were applying general principles of retroactivity. It's much more clear in Teague, because Teague did lay out some very specific principles. So your argument, I gather, is saying because the Supreme Court articulates these principles in contexts which aren't identical, therefore the general legal principle of retroactivity of procedural rules and substantive rules don't apply. But I don't think that's the teaching of either case. I think they were confronted in the context of which they were being raised, of whether a rule or a procedural rule or a substantive rule should be retroactive. And they're not inconsistent. I think Teague clarified it, don't you? The principles. I understand one's a 1983 case and the other's 2254, but.
That is right, Your Honor. Teague set out rules for retroactivity in habeas cases, but even if this court were to be concerned as to whether other prisoners could avail themselves of retroactive effect of rules, I think this court should rest comfortably on the fact that Lanier can only apply retroactively to an exceedingly slim category of cases where good time credit was lost prior to Lanier. The prisoner requested consideration of that video evidence, raised and exhausted that claim in state court, received no merits consideration there, timely raised the habeas petition, and remains in custody. We ask you to afford the same relief as in McWilliams v. Hawkins. Yes, Your Honor.
Chief, with your indulgence, may I ask one?
Oh, absolutely. Absolutely.
Thank you. So I talked with your colleague a minute ago about Carroll versus Johnson, and I just want to understand, do you believe that Carroll versus Johnson bars the use of habeas in circumstances like Mr. Wall's, not Mr. Wall's particularly, but in this type of circumstance with the prison disciplinary hearing?
I'm not certain that's to the answer to that question, Your Honor, but I'd be happy to provide an answer in supplemental briefing.
You don't need to do that. I just wanted to make sure if you had a position, I wanted to understand it. That's all. Thank you. Thank you, Chief.
Thank you so much.
All right. Thank you so much, Ms. Bateman and Ms. Samuels, for your fine job. And Ms. Bateman, I noted that you're court appointed. I want to give you a special thanks on behalf of the court. Lawyers like yourself help us tremendously in handling these cases, and thank you so much. We appreciate that. And Ms. Samuels, thank you for your representation in the Commonwealth here today. With that, unfortunately, we can't come down and shake your hands as we would in our normal tradition, but know that we appreciate it very much and wish that you'll be safe and stay well. Take care.
Thank you.
Thank you.
Good morning, Ms. Mitchell. You may proceed. Good morning.
Good morning. May it please the court. Kasdan Mitchell on behalf of defendants. Plaintiffs' challenges to defendants' EPA-directed cleanup efforts give rise to federal jurisdiction on two independent grounds. First, plaintiffs' claims challenge conduct by defendants undertaken at the direction of the EPA. EPA, not defendants, initiated cleanup activities at the Institute facility in 1984. And for more than 3 decades, EPA has directed and supervised those activities.
But factually, what was the direction? I didn't understand that. In other words, was there actually a CERCLA type direction to clean it up?
It was pursuant to their corrective action authority under RCRA. So Judge Niemeyer,
I thought that, I may be wrong. I'm asking this for information purposes, but I thought as the new law came into effect, there was new demands on cleanup and the whatever we call them, Dow or Union Carbide, fully undertook and sought a permit to clean up itself. It made an application to do that under the law, didn't it?
That's not exactly right, Your Honor. So back in 1984, it was EPA that initiated the corrective action plan, and that's what the district court found. It's also reflected in many of the EPA documents. It's on EPA's website.
I know, but did they actually issue a directive order?
They did. So there's an extensive process for corrective action plans under RCRA and in conjunction with CERCLA. So the first thing is you have to do testing and come up with a proposal. Now, at certain parts of that process,
the reason I'm asking for this is it sounds to me like they did do testing and did come up with a process, and they've been working all along. It seems to be in good faith. Nobody seems to be challenging that. But the question I'm focusing on, and it's probably not determinative, but the question I'm focusing on is the distinction between Union Carbide's carrying out an effort that is the government's effort and it's assisting the government versus complying with the law. As you know, the arising when 1442 makes that distinction between compliance with the law and helping the government carry out its own purpose and act. And it seems to me if there actually was an order with some resistance or denial by Union Carbide to clean up, that might be different than Union Carbide's recognizing that it was under a new law and now had to do the testing and comply with the law.
I understand the question, Judge Niemeyer, and I think you're right that our ordinary compliance activities, like the way in which we dispose of waste in the first instance, are part of our ordinary compliance obligations. But here it was different. So there is a mechanism under RCRA for landowners to undertake voluntary cleanup efforts. That is not what happened here. So here, EPA was the one who initiated the corrective action plan by identifying contaminants on the Institute facilities property. And they are the ones that directed us to engage in testing and compliance measures. And we did ultimately acquiesce in that. But I don't think it should make a difference for purposes of 1442 if the government is doing it itself, if it hires a contractor to do it.
Counsel, can I ask what I hope is a related question? So I thought that I understood, and I'm asking because I'm not certain about this, that RCRA's corrective action program or plan was limited to entities that either had a permit or were seeking a permit. Is that correct?
I think that's correct. It really isn't an issue here because we've had a permit for decades.
But it makes a difference in the context that you're saying, you know, the EPA is the one that initiated this, you know, and maybe this is just the play on words. They initiated the corrective action, but your company, and not trying to get into this whole successor issue, but your company effectively, they're the ones that had the permit or sought to get a permit. And so in a real sense, they're the one that's initiating a permit process, and the EPA comes back and says, well, in order to get a permit or to keep your permit, you have to do this corrective action. Isn't that the right way of thinking about the sort of timeline here?
So we had a pre-existing permit before EPA began telling us that we needed to be under the corrective action framework. And I don't think the fact that it's ultimately incorporated into our permit as opposed to a contract or a consent decree or something else changes the nature of the relationship between EPA and defendants. So it was EPA that said you need to undertake these corrective measures.
I understand that, but I'm just asking the factual question. I understand your argument. You want to say a permit's like a contract. I totally get that, and we'll talk about that. But as a factual matter, the relationship here is you have a permit. The EPA says to keep that permit or to get a new one, whatever it is, you must undertake this corrective action. And so it's part of the permitting process. And then we can talk about whether that matters or not, but that's the way to think about the relationship between the EPA and your company, is that as a permittor and permittee.
As a general matter, that's right. We're permitting, but the permit that we have.
What is the permit? Is the permit a permit to pollute? Because they are statutes that authorize activities where you can pollute to a certain degree, or is it a permit to clean up and comply with the law?
So our pre-existing permit, the one that pre-existed EPA's initiation of the cleanup activities, was to maintain this site and to have solid waste and hazardous waste disposal units, and it governed the way in which we were going to dispose of those. And just to
when was that issued, that permit?
It was issued back in, I believe, the 40s. Although it became a RCRA permit in the 70s when RCRA was passed. And I think this, just a little bit of statutory background may be helpful here. So RCRA, when it was first enacted in the 70s, EPA didn't even have broad remedial authority. It was not until 1984 when the EPA was able to undertake kind of the kind of remediation activities that are taken with respect to this property. And so it's, yes, we are a permittee and we're the landowner and we're operating pursuant to a permit, but the corrective action work that we're doing is independent of that. Now, in 2017 and 2018,
wait, I'm sorry.
corrective action plan.
Help me understand you. So I was with you right until you said, but we're a permittee, but the corrective action is independent of that status. Where I thought we talked earlier that the corrective action was limited to those who were permittees or those seeking permits, right? So help me understand how the corrective action is actually independent instead of, I thought what we said is that it is actually dependent upon.
So let me be a little more precise, but it was not until a few years ago that the corrective action plan was actually incorporated into our permit. So I think you're right that, you know, the relationship here is a government agency and a permitted company. But the corrective action plan was parallel to that. Maybe that's a more accurate description. Although now it has been incorporated, there's now been final agency action, at least conditional final agency action with respect to our cleanup efforts, and that has been incorporated into our permit. So for present day purposes, the corrective action plan and the remedial plan is a part of our existing and continuing permit. And so if I may just respond a little bit to the notion that, you know, because we're a permittee, that changes the nature of the relationship here. And I don't think that it should, principally because the federal government under CERCLA has taken on the responsibility of cleaning up contamination. And the direction that EPA
But it didn't take that step, did it? It didn't. Its activities in this case are activities of giving effect to the regulation under RCRA. It's supervising the cleanup effort and the monitoring that your client is proposing, and your client is reacting to the regulation, albeit a very complex and sophisticated regulation. But in other words, I'm trying to get at the notion of whether your company is assisting the federal government in carrying out something that the federal government is doing, or whether you're complying with law, because I think that is the issue under 1442 removal. I mean, this doesn't address, obviously, the 1331 issues, but I think the main argument in this case is under 1442, isn't it?
I think we think that we have grounds under both, but just to focus on the 1442 issue for present purposes. So the reason that we're assisting the government in carrying out its responsibilities is because the government has undertaken the responsibility for environmental cleanup when you have contamination. And although it was able to accomplish its objectives through RCRA, because we agreed to help and to work with them for the past 30 years to carry out those objectives, should not make a difference for purposes of whether we're acting under the direction.
No, but it depends on whether the government is functioning as a regulator or functioning for itself. In other words, our case, we've had a case where a contractor is putting asbestos in Navy prescribed items. The asbestos was specified by the federal government and the contractor put it in. We said that that person was assisting the government in having those material. But in this case, the question is are we assisting the government, or is the government enforcing a law with which the company has to comply? And to me, that is the core distinction that has to be made under a 1442A analysis.
That's right, Your Honor. And our position is that the government is carrying out its responsibility to clean up contamination, and it is using the RCRA mechanism. But this is not just a book of rules that we're complying with.
Except
this was a tailored, I'm sorry, Your Honor.
RCRA does not direct the government to clean up. It regulates the public. Your company, it's regulating. And it authorizes the government to enforce that. CERCLA allows the government to clean up, or it can impose that responsibility on the public. But it seems to me to be more, to be fairer to this particular case, we have to find out what was the government doing in this case? What was its activity, and was your company activity an effort to assist the government in doing its deal? And the question is, where was the responsibility under RCRA for the government to clean up?
So I think you have to look at cleanups in the broader context. So in the 1990s,
then you get into conduct that's not before us. This has never been declared a CERCLA site, or this is not a situation where the government has said, we're going to clean it up. Will you help? That's totally different.
So, Your Honor, I don't think it should be different for purposes of 1442. So the reason I said to look at the broader context is because in the early 1990s, EPA promulgated a rule that governed the intersection between RCRA sites and the CERCLA National Priorities List. And what EPA said there is, although we could list RCRA sites on the National Priority List, we think it's a better use of federal resources to try to accomplish that objective through the landowners. And so if we have a willing and cooperative landowner, we'll wait until they abandon or decide that they're no longer going to be cooperative before we'll list them on the national priority list. But that doesn't change the government's underlying obligation to clean up the contamination. And here, the fact that they've enlisted the private party to do it and that we've acquiesced in that doesn't change the fact that they're directing the actions that we took or did not take with respect to the remedial plan specifically. And that's different from
Counsel.
Yes, Judge Richardson.
Can I ask a slightly different question? So this, I get the argument you're making. I want to sort of get your response on another one before your time ends. So you're sort of relying on its responsibility, which is this language from Watson versus Philip Morris, where they talk about performing a job that the government would have had to perform. Tell me why I don't read that section of Watson to be expressly limited to private contracting, right? So, and we do not have a contract here. You might claim it's analogous to a contract, but we don't have a contract. And Justice Breyer seems to be quite consistent in saying that this is an exception for private contractors, right? That's, Judge Niemeyer's opinion with the Navy boilers, right? And similarly here, they're talking about the Winters decision, right? But those are private contracts, right? Where there's a contracting relationship, not a permittee relationship.
So first of all, I don't think you can read Watson to say that private parties can only remove in the government contractor relationship. Maryland versus Soper involved a private chauffeur.
Of course, but I'm talking about the section, you're relying on a section in Watson. And it obviously runs through all the alcohol cases, right? And tells us all about the dangers that we ought to be concerned about, right? But with the section you're relying on is itself limited expressly to private contractors? No?
Chief Judge Gregory, may I respond to the question? I see my time has elapsed. Judge Richardson, so that part of Watson is explaining why not all government contractors satisfy 1442, but I don't read that as saying that's exclusively a test with respect to government contractors. So here, where you have the federal direction kind of at every step of our remedial efforts, the question then becomes, well, are we just complying, or are we doing something that is not related to a governmental task? And because the federal government has taken on the responsibility for cleaning up environmental contamination, I think that passage in Watson should apply to contexts outside the government contractor context, because it shows that we are carrying forth, assisting the government in carrying out its tasks. Chief Judge Gregory, may I reserve my remaining time for rebuttal?
Yes, yes, you may.
Thank you.
Mr. Hogan?
Good morning, Your Honors. It's great to see you, and may it please the court. This suit involves state law claims filed in state court by a state actor arising from the defendant's contamination of West Virginia State University's property. Although the claims involve pure questions of state law, the defendants somehow seek to pull them into federal court under the federal officer removal and based on federal question jurisdiction. But the case is about contamination, not the cleanup. And the district court rightly remanded the case to state court for three reasons. First, it correctly concluded that the defendants are not acting under a federal officer simply because they are a permittee required to comply with the rules and regulations of RCRA. And second, under the third prong of the acting under test, there's no causal nexus between the contamination that gives rise to the state's claim and any federal authority related to the cleanup. Second, the ruling comports with the general purpose of the federal officer of removal.
Well, let me ask you, this is a very general question, and it probably doesn't resolve any of the particularized questions which we have to answer, which are really 1442 and 1331. But you essentially have a company working with the federal government, complying with the EPA laws. EPA is satisfied with what they're doing. They've reached full agreement. And you're now bringing a state lawsuit that potentially could impose a sanction that is different or inconsistent with what the federal government is authorized under federal law. How do we handle something like that? So
with respect to federal officer removal, it goes to the nature of the relationship. And it depends on whether the private actor is acting under the subject, guidance, and control of a federal officer. And the way that we handle—
I understand all that. I don't want the legal argument in 1332. I want to understand how we're going to have a state judgment come out that's inconsistent with the federal approval. And how do we handle that? Just generally, and then you can bring it back to 1442 if you want. But there's an underlying tension here, because since 1984, the company has been working closely with the federal government, been complying. They've worked out plans. They're doing testing. They've assessed the risks, and everybody's satisfied with what's going on. And the company has fully complied. Now, the state cause of action is at risk of imposing a sanction quite different and probably inconsistent. And is there, what comes in my question probably subliminally is supremacy notions or preemption notions or whatever. The idea is, how do we handle this tension?
I understand the question, Judge Niemeyer. There's not much conflict at all between the state law claims and the EPA approved permit, which, by the way, was issued in 2019, 2 years after we filed the state lawsuit. And the reason that there's no conflict there is that, first of all, limiting state court action conflicts with the Supreme Court's decision in Atlantic Richfield versus Christian, where even under a surplus site, the local landowners were able to bring state action for remediation that was over and above what the EPA had approved for a Superfund site that has been the source of a great amount of contamination in Montana. And they said it didn't strip the state courts of state law causes of action that arise under the state law, rather than arising under the CERCLA or a cause of action that arises under RCRA. And again, as you noted, as part of the RCRA permit, the facility has the obligation to address releases of hazardous waste. And in doing so, they have the discretion, just like they have the discretion in how they want to comply with the permit, they have the discretion to propose a corrective measure. And in doing so, the EPA then looks to whether that corrective measure proposal meets the minimum requirements of RCRA. That's it. And here they proposed an environmental covenant on the university's land, saying you can't use this land, you can't use the groundwater. And the EPA said, sure, that doesn't by itself pose a risk to human health or the environment. That's the test. That's what EPA is looking at. It has nothing to do with the state law claims that go to the university's use of its own property, how it sees fit. And quite frankly, under the federal question argument, what's the difference in the state law claims that the university brings here for the contamination of its property? How would they be any different if the defendants drove onto their property and dumped 16 loads of gravel onto their property? It wouldn't pose a threat to human health, but it would be a trespass, it would be a nuisance, and it would prevent the university from using their property as they see fit without incurring significant additional costs. And I think that that's how we deal with that tension there. And the fact that it's also a state actor, of comedy certainly supports allowing the state to bring such claims, contemplate such a circumstance. They say that subsection C says that when there's a release beyond the facility's boundaries, that where necessary, the party does have to engage in cleanup and remediation. But if they're unable to obtain, and this is a quote, if they're unable to obtain the necessary permission to undertake such actions, they're not relieved. Now I'm off script. They're not relieved of all responsibility to clean up the release that's migrated. And the EPA contemplates, and I quote, on-site measures to address such releases in circumstances where they can't get the consent needed to impose their corrective measures plan. And so this is not a case of direct authority imposed by the federal government. It's compliance, it's regulation. Every actor in this industry space gets one of these permits and has to act in accordance with the permit, which almost every section of the permits that are issued mirror or cite to the relevant regulatory regime to make it clear to the permittee where it can find the authority for the actions that it needs to take. And Judge Niemeyer, it reminds me of the Express Scripts case that we just addressed in a 28J letter. I mean, that's the sort of case where a private contractor is acting under a federal officer, in this case, the Secretary of Defense and the Department of Defense, to fulfill a statutory obligation that the government itself has to provide medical care to its members. And there's nothing of the sort here. There's no contract, there's no agency relationship, there's no payment made to Dow to accomplish some governmental objective. They're simply complying with the law as they engage in their for-profit business to make and create chemicals and bring them to market. And as a result of the law, got to clean the mess up that is made. That also brings me to the federal question jurisdiction. The states have an absolute right to bring state law claims in their state courts. And this is not one of the exceptional circumstances where there are state law claims that are masking some federal cause of action. And the question is not whether the plaintiffs could have possibly brought a RCRA claim under the citizen suit. Maybe they could have, but they didn't. And this court has long recognized that the plaintiff is the master of their complaint. And this isn't some. Let
me ask you, doesn't the savings clause in RCRA sort of answer that for you on your, in other words, doesn't it preserve state causes of action?
Yes, absolutely. It expressly does. And savings clause, just like, as the opposite to explicit preemption provisions in many statutes, savings clauses strike the balance in favor of the states and the state courts and state causes of action. And that's exactly what the savings clause does here. Again, I would point to the Atlantic Richfield versus Christian decision. That was even in a CERCLA circumstance, the Supreme Court said that it doesn't strip the state courts of jurisdiction to hear claims arising under state law. And I would also note with the federal question jurisdiction argument that the defendants make, they say it looks just like a RCRA claim, but they make that argument for the first time on appeal. The district court noted, and I quote, "Conspicuous in its absence, defendants do not cite any federal statutes that govern a purported federal cause of action." And you can look at the briefing below. It's in the district court docket 24 and 27. And they don't mention RCRA. They just cite a bunch of CERCLA cases. And so that's what the district court dealt with. And Judge Copenhaver said, this isn't a CERCLA case. And these CERCLA cases don't hold up. And it's telling that there's not a single case that defendants can point this court to that reaches the solution or the conclusion that they suggest here. The opening up, and I think that this court's, let me back up. The Supreme Court's decision in the BP versus Baltimore case highlights the need for a close and careful reading and sticking to the existing test that requires a special or unusually close relationship for federal officer removal. Because now, if the court were to rule in favor of the defendant's view on this, or the appellant's view on this, any entity that is operating under a federal permit, any entity that's operating under a complicated statutory regime, is going to be able to make a colorable argument that they're acting under a federal officer. And in addition to, and then we'll be able to shoehorn in any other bases for removal to get appellate review. And the long-standing policy and purpose behind these limited bases for appellate jurisdiction of removal decisions is because cases shouldn't be held up on esoteric questions of federal jurisdiction that have nothing to do with the merits of the case. And if finding that the defendants are acting under a federal office here would blow that statute wide open. And just addressing the last thing I wanted that I forgot to mention was the artful pleading doctrine. Courts have recognized the Mikulski Court, which is cited in the briefing, and the Third Circuit has all artful pleading collapses into complete federal preemption. And the question is whether there is complete federal preemption on the causes of action, which there's certainly not here. And although the defendants may have a colorable federal preemption defense, they can make that in state or federal court. It doesn't much matter. Both courts are obviously competent to deal with questions of limited preemption. And this is not a case where there is complete federal preemption. The RCRA Savings Clause makes that very clear. And if the court doesn't have any further questions, I will turn it back over to Ms. Mitchell.
Thank you, Mr. Hogan. Ms. Mitchell, you reserve your time.
Your Honors, if I could just make a few points in rebuttal. First, counsel discussed, how we are a permitted, this is just a part of our permit. And I think it's important for the court to understand that not all permit conditions are created equally. And this is not, finding federal jurisdiction here is not going to sweep in the right for any federal permittee or even any environmental, any environmental case to come into federal court. Instead, there's a distinction that RCRA itself draws between its ordinary compliance and the disposal of hazardous waste and the corrective action plan that it initiates and that it directs. And here, not even all cleanups would be subject to federal officer jurisdiction. It's just cleanups that are initiated by the federal government and where we're able to show, as we have, the close relationship between the federal government and the actions that we took with respect to the property. And I think it would be a perverse result to say that a landowner who acquiesces in the demand that EPA places on it with respect to cleanup, rather than abdicate its role, it can be deprived of its federal forum to hear its concededly colorable federal defense. So we would urge the court to reverse on the grounds of 1442.
Can I make sure I understand that argument? So your point about acquiescence is that you acquiesce to the demands. The other option for you was to stop making chemicals, right? I mean, that's the other. You could say, well, I don't want a permit anymore, and now that might bring in other obligations, but that's not acquiescence, right? That's getting the benefit of a permit. I'm just not sure I'm following that.
Not necessarily, Your Honor. I mean, we don't know what would have happened if we hadn't agreed all along to kind of do what EPA has told us to do. I do think you're right, ultimately, that this is bound up in our ability to run the property. And so we very well could have permit-related consequences for refusing to comply with this aspect of the plan. So I don't want to say, you know, we would have completely had no consequences if we didn't continue to follow EPA's instructions with respect to cleanup. But I don't think it changes the fact that EPA was directing this part of our activities separate and apart from our ordinary compliance activities. And that is why—
Explain how that's just this piece. I understand your circle argument, but why is that different from Watson, right? Because they're sort of saying the same thing. You can't sell cigarettes if you don't do this testing, and here's how you got to do it, right? How is that different from the actual facts in Watson?
So I don't think you can divorce that from CERCLA. Because unlike selling
I understand
cigarettes—
that, but if so, your argument, I just want to make sure I understand. Your argument is dependent upon this sort of secondary argument that because of CERCLA, it's ultimately the government's responsibility. If CERCLA didn't exist, you would agree this is Watson and we're done.
I'm not sure. I think CERCLA makes this an easier case because you have a federal statute that has
assume
placed—
CERCLA doesn't exist. Explain to me how this is different from Watson.
I think we still have an argument that cleaning up contamination is a federal responsibility, and there may be something short of CERCLA on the books in that hypothetical. So I can't go all the way to say that if there were no CERCLA, that this wouldn't be a federal responsibility, because I think if a house burns down in a neighborhood and it's abandoned, the government is going to have some sort of responsibility to ensure that that site does not harm human health. But I think precisely because CERCLA is in place, we know that the federal government has taken on the responsibility for cleaning up contaminated sites. And if they're able to accomplish those objectives through a permit holder, that doesn't change the fact that it's governmental or that they're directing that aspect of the permitted activities. If I could pivot for a moment to federal question. So Mr. Hogan spent a lot of time talking about the environmental covenant, and I think that underscores why there is a substantial and disputed federal issue in this case. So what he said is if they withhold consent for the environmental covenant, then we are going to have to go back to EPA, make a showing that we weren't able to obtain that, and then EPA will direct a plan B. And I think the fact that they're trying to proceed in state court and have the state court sit in superintendence over this remedial process that's very much ongoing just underscores the federal interest at play here. And to be clear—
How do you address the savings clause?
So I think a couple of things. First of all, we're not saying either for purposes of federal officer or for federal question jurisdiction that some of their state claims can proceed. To be clear, under federal officer, all of their state claims can proceed as they're pleaded. We just get a federal forum for our federal defense. But as to federal question, I think first of all, the RCRA citizen suit provision is broader than the savings clause.
Is that the way you construe the savings clause? It seems to me the savings clause is suggesting that a person can pursue state causes of action implicitly in state court. There's no federal jurisdiction mandated. It's not exclusive federal jurisdiction under RCRA, is it?
Chief Judge Gregory, may I answer
certainly,
Judge
yes.
Meyer's question?
Yes.
Judge Meyer, I think that's right if we were making a strictly complete preemption argument. RCRA has not completely preempted the field, but I think there is an argument under both artful pleading that what they're actually pleading here is a challenge to our permit and to the judgment that EPA made. And in addition, under—
Well, how do they take care of— they're claiming fairly simply that there is a trespass and a nuisance under common law. And they want relief beyond what has been approved under the RCWA process. They want removal so that they can put in a well to drink water there. What's wrong with that?
So, Your Honor, there's nothing wrong with those claims. But if you look at count 1 and count 2 of their complaint, where they're asking us to completely cease and desist all operations and asking the state court to sit in superintendence over the remedial activities, that is seeking to usurp EPA's authority.
You can answer that in the complaint. That's the remedy. The question, they have a cause of action. They're alleging straightforward state causes of tort causes of action. And it doesn't look like they're purporting to assert a RCWA claim. And as a matter of fact, RCWA recognizes they can assert those causes of action. Now, what's wrong with letting the state handle that? And you can raise, I think the preemption is a mighty powerful argument, maybe, and maybe the sanction might be inconsistent, which can also be a reason to oppose a particular type of sanction that's been imposed. But the problem here is jurisdictional. The question is this 1331 rising under the federal law?
So, Your Honor, I don't think that we have defenses, preemption, statute of limitations, and otherwise as to their purely state law claims. But if you look at, I'll direct you specifically.
That's a defense too, isn't it?
That's right.
It may be a very good defense.
That's right, Your Honor. And we're not saying that that's the grounds for federal question removal. And if I could direct you to count 2 of their complaint, which doesn't cite any state law, where they're asking for a permanent injunction and asking the state court to sit in supervision over the remedial efforts. That is very much.
Those are the way they're pleading the case. I must say, we see this regularly where people assert a cause of action for damages, a cause of action for injunction, a cause of action, which is not good pleading. In other words, those are remedies. They're based on some substantive law, a cause of action. But the fact that that's the remedy they're asking for, the basic allegations in the complaint are that your client has permitted toxic chemicals to come onto their, or has actually caused toxic chemicals to come onto their property and damage their property. And they want the chemicals removed, or whatever they want, whatever the sanction is. But the question is, isn't that a legitimate state cause of action?
So again, I mean, we have ordinary defenses to those that don't give rise to federal jurisdiction, but I don't think you can divorce the claims from the relief that they're seeking and the allegations they've made in support of that.
Well, sure you can. The range of remedies is something for the court to establish. But the cause of action, you have to have the fact of injury. But after that, what the court designs is damages. It may be no damages, or maybe, well, there's tons of defenses. There's preemption defenses. There may be limitations defenses and all these things. But, and you may have you have some equities going for you. Your company seems to have been doing very well with the federal government under the pollution laws. And you're not somebody that has just trampled over it and then run away, and you're solvent and all the other things. But we're going to a very beginning question of who's going to decide these issues. Anyway, that's probably not a question. I'm telling you what the puzzle is.
Thank you, Your Honor. Chief Judge Gregory, may I just briefly wrap up?
Very briefly.
Yes, John, I was just going to say that precisely because I think within the federal question umbrella, there's room for recognizing the importance of federal interest. And this case satisfies that burden, and we would ask, or excuse me, satisfies that standard, and we would ask that this court reverse. Thank you.
Thank you. Thank you, Ms. Mitchell. Mr. Hogan, again, we cannot come down and greet you as we would love to do, but know very much that we appreciate your arguments and your help with the court in handling these very difficult matters. And I wish you well, be safe, take care.
Thanks, it was a pleasure to see you.
Same here.
Thank you, Your Honors.
Thank you, bye-bye.
Thank you, Chief Judge Gregory. Should I go ahead?
Yes, Mr. Lynn, yeah, you may.
Thank you. Good morning, Your Honors. Chief Judge Gregory, may it please the court. Albert Lynn on behalf of the appellants. The Supreme Court has recognized that some jurisdictional rules derive from longstanding practice in American courts. In its words, a century's worth of precedent and practice in American courts can rank a practice as jurisdictional. And that is because, as the court has also said, the Constitution established that judicial power could come into play only in matters that were the traditional concern of the courts of Westminster, and only if they arose in ways that to the expert field lawyers constitute.
That's really too general to begin your argument. I think if you want to start with a generality, you ought to start with Steel Company case, which the Supreme Court talked about jurisdiction going to the power of the court to act. And in this case, the power to act is given to us under Title IX, alleging adequate cause of action under Title IX with named defendants, time, place, and manner, all alleged in detail. And the only question is the rule that requires the naming was violated. That is not a jurisdictional question under any case that we've been able to find. Now, maybe you can address jurisdiction in the sense the Steel Company case talked about it, which goes to the power of the court to make a decision.
Of course, Your Honor, but I think the question of jurisdiction goes to whether or not there's a case or controversy before the court. And I think—
Just a minute, a case or controversy is a dispute. There's a real dispute here. As a matter of fact, your client was taken before an agency and reached a settlement agreement under this dispute. And now this is a claim for damages. I mean, this case or controversy is, again, so general. There's a real case here.
Well, Your Honor, what we think that the history shows is that there is no case within the meaning of Article 3 where the plaintiff has not put his or her true identity before the court. And I think that is ultimately the question here.
The identity was before the court. Everybody knew her name. They were involved in proceedings that were alleged specifically. They knew exactly her name. Every party was described by date, time, and place as to what was involved. The fact is, she alleged in her complaint, I'm embarrassed, I want to maintain my privacy, and I'm going to use Jane Doe. But that violated the rules. But the fact that there was no case or controversy, or that you have to I mean, this is not a case where a phantom is coming in with respect to a phantom event. Obviously, there's no case there. But I don't think you're getting anywhere, at least with respect to me, by arguing case or controversy in Article 3. We have jurisdiction under Title IX, and there's a real incident alleged by real people against real people. And they state a cause of action under Title IX. At least you haven't challenged that. So the only issue, I think, is what is the remedy, appropriate remedy, for violating Rule 10.
I understand, Your Honor, and I understand that the history may not convince you, but I think at the end of the day, that's really where this goes. We will recognize, as the other side has pointed out, the Supreme Court has been very strict about jurisdictional rules, and this is obviously not a jurisdictional rule that has been adopted by Congress. We think that it's a jurisdictional rule that is evidenced by history and practice, in the sense that I think what the treatises that we've cited and the cases, including the Indiana Supreme Court and the Connecticut Supreme Court, show is that there is no case commenced, and so therefore there is no case.
Counsel?
Yes, Your Honor.
Can I want to just talk to you a second about the historical argument. Help me, you just used the phrase, and I know you well enough to know it wasn't loosely used, true identity. And when I looked at the sources that you give, you include things like it describes the proper name. Can you help me understand what you mean by that? Right. So, for example, is there any suggestion that if somebody, I filed a suit under J. Richardson, even though that's not my government name, my full name is Julius Richardson, that would somehow be a jurisdictional rule, or perhaps I used initials, like my good friend Judge Wilkinson, who uses an initial for his first name. That might not be his proper name in a government sense. It might not be his true identity in some sense. But is there any sort of line that's being identified here between sort of a Jane Doe and a full proper name?
No, Your Honor, I think to answer your question, if for example, you were to file a issue, or if you misspelled your name, for example.
A nickname is not my proper name.
That's true. It does discuss proper name, but it also does discuss that, there are some places where the initials were appropriate. And that is why I use the phrase true identity, because I think that's what these cases and the history is getting at, which is that the names have power. I think that's something that humans inherently recognize. I think that's evidenced by the fact that there are individuals who want to proceed pseudonymously, even though they're willing to plead other facts about the circumstances, and other facts about themselves. But it's the name ultimately that is important. And our position here is that we think the history shows that until that true identity is proffered to the court doesn't. And I think one reason that might exist is the reasoning that's offered in the House case with respect to deceased plaintiffs, is that while you have these other allegations, you don't know whether they're tied to an actual person until that person is willing to put him or herself before the court. And it can be under seal. We're not suggesting that.
So one last question, then I'll let my colleagues go. So when I look at those sources, the references to true identity and proper name, they would seem to suggest that the whole practice of using Jane Doe is improper, right? And if it's a constitutional jurisdictional provision established by history, how can we ever use Jane Doe, right? What allows us to overrule that constitutional history, if it is a constitutional history requiring a proper name in order to satisfy the jurisdictional burden? How does a motion to proceed somehow change that?
I understand the tension, Your Honor, and I think our answer to that is that the history doesn't say what a court can do about it if it knows that there is indeed a true plaintiff behind the complaint. And the Connecticut case, the Buxton case, the court there says, we recognize that there are these circumstances where there may be reasons to allow someone to proceed pseudonymously. And so the practice should be that the individual should put that name before the court and ask for permission to proceed pseudonymously. We don't think that the history precludes that a way of dealing with what are some very real concerns that we don't deny in this case or in others. I think,
but doesn't that suggest, and I know I said I was going to stop, but I'm not doing it. But doesn't that suggest that it's not the jurisdictional requirement that you're describing, right? If those very sources are saying, well, yes, you can proceed under Jane Doe, you just need to file a motion before you do it, right? And there may well be really good First Amendment or common law right of access reasons for requiring the motion, but why doesn't that suggest that the quote unquote rule is not of constitutionally, jurisdictionally significant import?
And that comes back to the point that I started with, which I recognize is not swaying Judge Niemeyer, but that I think what the history shows, at least what our position is that the history shows is that to initiate that case, you need to be willing to let the court know, take the steps that let the court know that you are indeed a real person. And that involves putting that name before the court. And that is the jurisdictional rule. That's the jurisdictional fact that must exist for the case.
It's jurisdictional. The court lacks power to act on it and to authorize it. It could not be authorized as the rules do. And it just represents, I think, a misunderstanding of what jurisdiction is. It goes to the power of the court to act. And I can tell you that I once had a case where somebody misalleged corporations. They juxtapositions. There were two corporations. They juxtapositioned portions of their names. So both names were inaccurate. And there were motions all over, but didn't go to the power of the court. We sorted it out. They amended it and filed, and so you knew which party was stuck with which allegations in the complaint. But the notion that you have to put it before the court, I've never seen that either. The notion is that you have to identify it for the defendants.
I understand.
In other words, when somebody's dead, it's a phantom case when somebody doesn't exist. But here we know everything is real. In real life, there's a real dispute. There are real parties. We have a deficiency in one party used a name that was not authorized by the rules. And you're arguing that that's jurisdictional. We lack the power to even address it.
Yes, Your Honor.
Complaint.
Yeah, Your Honor, and that does, you put your finger on exactly what the question is here. And I think it really does turn on that one question. If this court thinks that it is simply a pleading rule, then we don't prevail here in the appeal. If this court concludes that it is a jurisdictional rule, then we do. And again, I think the reason why, our basis for arguing that it's jurisdictional is we believe that it fits within this narrow class of rules that are historical. And Judge Niemeyer, to use your words, I think the reason why it goes to the power is because, and understanding that the facts are different, but because like in the House case where there is no plaintiff, that goes to the power of the court because there is no case before it. And that is, and again, I think it really does boil down to as simple as that. I do want to make sure, just to be clear, we are not suggesting that this plaintiff could not ask for permission, must ask for permission at the outset, that there's a dispute between the parties. My friend has cited a number of cases where plaintiffs have asked later for permission to proceed pseudonymously. And our view on that is that you can do that. You can ask later. That would essentially cure the jurisdictional defect going forward. And the only reason that it's a
how can the court act on that if it's jurisdictional? I mean, jurisdiction goes to the power of the court to act. What if the complaint alleged diversity, alleged the citizenship of the parties, but failed to include the jurisdictional amount? The jurisdictional allegations are defective. The court doesn't have jurisdiction until that's demonstrated. But we let them amend that complaint to put in the jurisdictional amount.
Yes, Your Honor. Two answers to that. The first is on the diversity point. I think that's a classic 1653 situation, as my friend has noted. And that's because that's a defective allegation. There's been a misstatement or a failure, really, to accurately describe the facts as they exist in the world. There may be, in fact, an amount in controversy that is sufficient to satisfy diversity jurisdiction, and they just didn't include it in the complaint. So that's a defective allegation. But as the Supreme Court said in Newman Green, 1650.
Well, isn't that what you're claiming here? Jane Doe is a defective allegation. And matter of fact, Jane Doe alleged, this is not my real name. I am a real person and I'm using a pseudonym to protect my privacy. That's what she alleged in the complaint. So that's a misallegation, right?
Respectfully, Your Honor,
the right name, you'd say we'd have jurisdiction.
I don't think it is, and I think that gets to sort of fundamentally what our point here is, which is it's not simply the failure to include the name in it's the act that has not been undertaken. So, for example, if you have a diverse defendant who is in fact not diverse, right? Their place of citizenship is the same as the place of the plaintiff. That's facts in the real world where there is no jurisdiction. You can't correct that. And our contention here is that the thing that has not occurred, that did not occur at the outset at least, but it has occurred later in this case, the thing that has not occurred is the plaintiff has not proffered her true name to the court. It's that act of putting the name before the court that gives the court the power to act. And so, Judge Niemeyer, that's to your earlier question, how can the court act on the request? I think the request itself, once you put that name before the court, that creates the case. And then, of course, the court can then decide whether or not, under the factors in this, in this circuit in James versus Jacobs, whether it makes, is appropriate for the plaintiff to proceed pseudonymously. So I think that really gets to the heart of the question, which is, is this act, does it have jurisdictional consequences? I think everybody would agree that a plaintiff does not have the right to proceed pseudonymously, that it is, as the court said, this court has said, it's a dispensation and it's a rare one at that. And so really the only question here is, of course you have to ask permission, but does that have jurisdictional consequences? And I see my time has expired.
All right, thank you, Mr. Lin. Mr. Singh.
Thank you, Tejinder Singh, for the appellee. And I'd like to start where Judge Niemeyer's questioning left us. I think it's well acknowledged that the plaintiff in this case is a real person. I actually want to take a moment, Judge Niemeyer, to express some gratitude to you for saying it so specifically, because I have the plaintiff in the room here with me, and I cannot tell you how important it is for people in her situation to be seen as real people. And she came for that purpose. And when you think about the power of courts to act, to pursue justice for real people, I think it is quite well established that the form of the pleadings, whether the plaintiff is identified by a true name, by a nickname, by initials, or by an anonymous pseudonym, is simply immaterial. The defendants, when you look at their opening brief, they had it right the first time. On page 20, they talk about their common law history, and then they segue immediately to Federal Rule of Civil Procedure 10. And they say, this is where this principle is embodied. And we understand that to be a potential interpretation of the rule. And we've argued in our brief that Rule 10 could be interpreted to allow us pseudonymous filing and a motion to come later. That's a debate that I suppose the parties can have, but it's really not even before you today. Here, the defendants have acknowledged that they can only win if you agree with them that not only is this a defect, but a jurisdictional one that goes to the power of the court to hear the case at all. And when they talk about the common law and the history, I want to make a couple of points about this. So first, the common law pleading requirements have never been held to determine the metes and bounds of Article 3 jurisdiction. Just to give you one really clear example, if at the common law, courts required issue pleading, where plaintiffs could only present a single claim in a cause of action, defendants can only present a single defense. That was then replaced with code pleading in the 19th century, and then with the system we have in the Federal Rules of Civil Procedure in the 20th century. But nobody would argue that Article 3 does not reach a case if it involves two claims in the same cause of action. Indeed, the common law pleading standards have routinely been criticized for being hyper-technical and not focused on substantial justice. And so when you see what's happened with pleading generally, the evolution to notice pleading, you see that we've moved away from those, and no court has ever held that this raises a constitutional concern. To the extent the common law is relevant to Article 3 standing, and these are the cases that the defendants cited for the first time in their reply briefs, it is because the common law can sometimes inform how particular elements of the Article 3 inquiry work. So for example, in the Uzig Bunum case, which was about whether nominal damages are a form of relief sufficient to satisfy Article 3's redressability requirements, the court considered the common law to say, yes, they are. But there is no similar precedent anywhere saying that there is some freestanding requirement drawn from common law pleading standards that you would import into Article 3. In this case, the other side has effectively conceded that all of the Article 3 elements, that is injury in fact, traceability, and redressability are satisfied. They don't have an argument that one of those isn't met. The most they've been able to say is that if you don't know the plaintiff's true name, you can't be sure whether they're met. But that is false. The complaint includes well-pleaded facts, as Judge Niemeyer notes, that lay out all of these elements in detail. Those facts can be controverted. And if there's some question about whether there actually is a real person who is a plaintiff, then of course you can have that discussion too. And if a lawyer has lied about that, they should be sanctioned. But this is not a jurisdictional question. In fact, it is exactly the type of issue that courts resolve every single day. The only other thing I'd want to say about the other side's history and common law argument is that, and they've acknowledged this candidly in their briefs, it is in the teeth of at least the last 50 years of precedent. Since Roe versus Wade, there has been, as the other side describes it, an explosion of pseudonymous filings. And courts have routinely addressed all of those as routine pleading issues under Federal Rule of Civil Procedure 10. And so there really is no argument, I think, consistent with controlling precedent that would allow you to find the issue in this case jurisdictional. The last thing I want to address before, and I'll stop if the court has no questions after this, is my colleague on the other side says that this is not the type of thing you could deal with through amendment of a complaint, because there is some act that hasn't occurred, and so you don't have jurisdiction as a matter of fact. He says the act that hasn't occurred is the plaintiff hasn't given her name to the district court. But Judge Niemeyer, as your question illustrates, the same thing could be said in a diversity case. A defendant could say, well, the act that hasn't been done is telling the court where the parties reside or telling the court the amount in controversy. That's not an act outside the pleading. It's merely a description of the underlying facts. They don't like the words we use to describe the plaintiff, but there's nothing to say that the plaintiff herself is not a real person with real injuries, traceable to the defendant's conduct, and redressable in a federal civil rights action like this one. If the court has no questions, I'll happily turn it over to my colleague from the other side.
Mr. Sin, thank you so much. Mr. Lynn, you have some time reserved.
Thank you, Chief Judge. I'll try to be brief. Just a couple points. The first is I do want to emphasize that there are 3 circuits on the other side of this issue, the 6th, the 8th, and the 10th. The 10th is obviously the first in the Gibbs case, where they held that this is a jurisdictional issue where a plaintiff has not put his or her true name before the court, and that means that the case has not commenced. My second point that I did want to make is, as my friend on the other side noted, the court has said many times in recent years, the Supreme Court, including in the TransUnion case and the Uzubunum case, that common law does inform what constitutes a case or controversy. And I don't think the line that he's drawing in terms of elements of cases or controversies is one that the court has drawn. I think it, again, as I quoted earlier, and again, respectfully, Judge Niemeyer, just to come back to that point, I think the court has said that the Constitution's limits on cases or controversies can be informed by and can be found in the common law. And then my final point.
Can you respond more specifically to your colleague's position that TransUnion in the nominal damages case that I cannot pronounce, that those are cases about informing the meaning of identified Article 3 elements, where what you're suggesting is that, you know, common law pleading requirements that are sort of apparently freestanding are being incorporated into Article 3 elements. I mean, that does seem to explain both the nominal damages and TransUnion case. Why shouldn't I accept that distinction?
Of course, Your Honor. I think there's 2 answers to that. The first is, I think the principle that is followed in those Supreme Court cases is the idea that the common law informs what cases or controversies means within Article 3. And in those particular cases, the way that that principle is carried out and effectuated is that it informs the kinds of injuries that would have been traditionally understood to be a case or controversy. So I don't think that there is, on the face of that general rule, the limitation that my friend suggests. I think perhaps his better point is the idea that, you know, not all pleading requirements and standards dictate what constitutes a case or not. And it's a fair point. And I think the distinction here is that we're talking about pleading, you know, practice and requirements for initiating a case. And that gets back to our point that we think the question here is, these are requirements for commencing a case. It is therefore not a case that within the expert field of lawyers would have been something over which the court has power to act. So I think those would be my 2 answers to that question, Judge.
Right, and then one final piece is, so why is the act of not telling the true identity different from the act of not telling citizenship? The sort of distinction he makes there that your colleague makes. Why isn't that correct?
Of course. So in the case of the citizenship, I think ultimately the question is, under the facts that exist in the world, right, as they really are, whether they've been pleaded in the complaint or not, does jurisdiction exist? And so in the case of diversity jurisdiction, the facts that are relevant are the parties sufficiently diverse, completely diverse, and then in addition, is there a sufficient amount in controversy? And I think the issue there if you failed to plead a certain part of that, but it is true in fact, there is jurisdiction in the real world, and it's a misstatement, it's a defective allegation for not
Seems
mentioning.
to me that's you just basically described your case, because the plaintiff is a real person with a real name, and actually disclosed in her complaint that she's using a pseudonym to protect her privacy. But in reality, she is a real person, and she was just identified herself incorrectly, almost identical to what you just said. I don't understand what the distinction is.
Mr.
Yes, Judge.
Mr. Lane, so you would say that an allegation could not cure a jurisdictional problem, correct?
That is correct, Your Honor.
So that means that if she said she's Jane Doe in style, it didn't identify herself, but in her allegations she did, it would still be jurisdictional because she didn't say in the style what her name is?
Yes, it's jurisdictional because the act that's in question is, and I understand it's a fine line, but it's—
That's a fine line. That turns logic on its head. In the allegation itself, she identified herself, and that still be jurisdiction.
Oh, no. I'm sorry, Your Honor, I misunderstood. If she did not identify her true identity in the allegations, it doesn't matter what—
But I thought you said that the reason is it's a problem with the allegation. That's why it's not jurisdictional in terms of citizenship.
Your Honor, I see my time has expired, if I may.
Yeah, you may.
So in the instance of citizenship, it's a defective, it's the fact that the true facts in the world that create jurisdiction were not described in the complaint. The issue here is that the true facts in the world, under those facts, there is no jurisdiction. And that is because the fact that is needed is that the name has to have been put before the court. That's an act that she has not undertaken. And so therefore, there's nothing that she can say in the complaint that can change the fact that she didn't do that act.
All she has to do is change her name, put the real name in. Well, you said there's nothing she can do. It's just a pleading issue.
Right, barring actually undertaking the act herself. And that is, Judge Niemeyer, to your point, if she were to amend the complaint and put her name in it, that would be undertaking that act and therefore creating jurisdiction. And unless there are further questions, we'd ask the court to reverse. Thank you.
Thank you, Mr. Lin. Mr. Singh, thank you much for your arguments. We appreciate them very much. Again, we would like to come down and shake your hands. We cannot, but know that we appreciate very much your being here. We appreciate your help to the court, and I hope that you all be both safe and well. Take care. Bye-bye.
Thank you.
All right, we'll proceed to our last case for the day. Mr. Hill, you may proceed.
Thank you, Your Honor. May it please the court. My name is Richard Hill, and I represent Greater Richmond Transit Company in this case. This case is about whether or not GRTC, a private company, can decline to accept political advertising on its buses, and whether those decisions regarding advertising constitute state action for purpose of 42 U.S.C. 1983. As this court is aware, private companies such as GRTC are only subject to constitutional constraints through enforcement under 1983 in very limited circumstances. And as this court stated in Mentavlos versus Anderson, and has restated numerous times, a determination of whether a private party's allegedly unconstitutional conduct is fairly attributable to the state begins by identifying the specific conduct of which the plaintiff complains. And this is obviously a very factual, specific inquiry, but this court has reinforced that premise numerous times, including as most recently as the Peltier versus Charter Day School case, which was decided just last month. But as most applicable here, the Phillips versus Pitt County Memorial Hospital and Moore versus Williamsburg Regional Hospital cases discuss this particular inquiry. So the inquiry in this case is the GRTC's decisions with respect to advertising, are those decisions government action under 1983? And our position, as we've set forth in our briefs and previously, is that they are not. The decisions are made by GRTC employees, and in some cases in consultation with the outside advertising agency. There is undisputed evidence in this case that none of those decisions are influenced by or directed by any state actor or even by GRTC's board. They are independently made, and so GRTC's decision in this particular case to not run the plaintiff, White Coat Waste's ad, was not state action, and therefore is not subject to 1983, and that by itself is a sufficient ground to dispose of this appeal, which is the principal issue or the number one issue that GRTC has raised. The second issue
before you go to the second issue, I wanted to give you a chance to talk, but can you talk to me for a minute about LeBron? And I take, well, maybe tell me why you think LeBron doesn't control here, particularly considering, the facts of LeBron itself.
Well, our position is, as we've explained, and I think that this court has indicated, although this court has never had a decision in LeBron specifically related to a transit company or one that's structured quite similar to ours, but our position is that LeBron is essentially requires several things in order for the test articulated to apply. The first is that the corporation has to be created, or the entity has to be created by special law. And that was really critical in LeBron. And as we set forth in our brief, our reply brief, the Congress in enacting the legislation set forth very lengthy oversight and discussion and rules about how this corporation was going to be set up, what it would do, the powers that it would have, how it would be financed, how its board would be composed, and that all those decisions were taken in an act of Congress. In this particular case, GRTC was created under Virginia's General Corporation Statute, and it was created, it was created by the Richmond City Attorney to create a company that the company itself was created under Virginia law, and there's no specific either state or local or any law.
So let me break that piece down just a little bit, right? So in LeBron, Amtrak, colloquially, we'll just call it Amtrak, was created under DC corporate law, right? So it was created under DC corporate law, and it had sort of specific restrictions that were an act of Congress. But the act of Congress just authorized its creation, and it was created under DC corporate law. And here we've got Richmond that authorizes the creation of this entity, and it's created under Virginia law. Now, the only distinction between those that I can see is that, the Congress added these sort of special provisions for Amtrak that were different from DC corporate law. And obviously Richmond didn't do that because Richmond has no power to control Virginia corporate law and doesn't have the authority to change what Virginia corporate law permits. Is that the distinction that you're drawing? So
Your Honor,
a municipality could never satisfy LeBron because it can't change generally applicable corporate law?
I think that would certainly be my position with respect to an entity created in Virginia. I mean, based on the Dillon rule and based on the unique powers that they have, only the Commonwealth could create or charter a corporation or enact legislation of special legislation in this case that would have the effect of creating a corporation. What was created under the DC law in the case, the difference is under Lebron, what was created under the DC law was essentially the corporate form, whereas everything else about the corporation was created by the special legislation. And in this case, neither of those two things occurred. I mean, the corporation was enacted under state law, and all of the corporate particulars are set forth in the general corporation documents. But more importantly, Your Honor, and as I think is applicable specifically here, what happened with GRTC is essentially indistinguishable with what happened in the Phillips versus Pitt County Memorial Hospital case. There was a North Carolina, I believe I'm right about that, North Carolina state statute that authorized localities to create create corporations and create hospital corporations in that particular instance. And so by virtue of that law, the locality created a corporation under the general corporate statute of North Carolina.
Right, but there, the court just says, the court doesn't actually hold that, right? The court just says there's a failure of proof, right? They had the burden to show it was created by special law, and they failed to make an allegation, right? That's the holding, right? They just flat failed to make an allegation. So that's the holding. Now there's subsequent discussion that says, maybe, we don't know, but maybe this was done at they say the instance, presumably at the instance of Pitt County, right? But the point of that is that they don't know because there was no allegation, right? So I don't understand how that helps us at all here, because there are allegations here, right?
Well, I mean, I think if you look at the particulars of the legal particulars behind the situation in the Phillips case, I think it does give us the necessary information and background. And the court assumes essentially what did occur, which is that it was created by the locality, or at the instance of the locality, I believe is the word that's used in the opinion. And that's sort of what we have.
Presumably, right? Because it's already held in the previous two previous sentences that there's no allegation. This is a failure of allegation. And then it comes back and says, we can presume that this is how it happened. But the point is, we're having to make presumptions here because there's a fundamental failure of allegation, which isn't surprising because there's only one reference to LeBron in any of the briefing, right? That's why they didn't make any allegations about it, because that wasn't the argument they were really making.
Well, I would, with respect, Your Honor, I mean, I think the language that's stated in that opinion, and again, I don't disagree with you that it seems like it's an issue that comes up sort of late in the decision, but this court says very clearly that it is plain enough that PCM-HI was not created by special law. Rather, and then it says it was created in 1953, and then the presumably part, right, under the general nonprofit and corporation statutes in North Carolina. And then in 1998, PCM-HI filed restated articles in order to receive the conveyance of the hospital from the county. So this court looked at that issue and made the finding in that case that it was plain that PCM-HI was not created by special law. And the mechanism there is the same.
Though, right? The point of that is that follows them saying they point to no allegation in the complaint, right? And so then they make some assumptions about what might be the case and reject those. But it seems to me, and I don't want to belabor the point, but what I'm having trouble seeing is how the holding there is controlling on us here. I know you make that argument in your brief. I'm just having a hard time seeing that.
Well, I mean, the reason I think it's binding, or at least the reason I think that it governs this case is as I indicated, and I don't want to belabor the point and just simply restate what we argued in the brief, but the point is simply that the mechanism The critical issue is the mechanism by which it occurred is almost identical to the mechanism under which we're talking about with GRTC. There's a general power conveyed by the state, a general power. In this case, the general power that was conveyed was that the power of Richmond to take certain acts in furtherance of its transportation, one of which could have been setting up a corporation under state law. And there is and that's the extent of what's done. And then the localities take the specific additional steps of doing that. But Your Honor, LeBron, that's the reason why LeBron, in our opinion, doesn't apply to this case, because it doesn't satisfy the special law portion of the test. We would argue further that it doesn't apply, that it doesn't satisfy the control test, primarily because even though we concede that the county, that all the stock is owned by government, that in and of itself is not enough. There has to be specific control over what's at issue. And the thread through all of these cases that I just cited, culminating most recently in the Peltier cases, is that the decision that's being made has to be done as a government action. So the additional control part of the test requires that there be some evidence, or that there be some showing that the actual challenged action is in fact an action of the government, and that doesn't exist in this case. And I would note that in Peltier, this court specifically reserved the idea that there might be circumstances under which the schools that were issued there could be subject to 1983. But in this particular case, in the Peltier case, that decision, which had to do with the dress code and the implementation of that, was not, because it was not, there's no evidence that the state or that governmental actors influenced and controlled that, which is essentially the situation that we have in this case. So,
although in Peltier, there's no suggestion that the state owned the stock of the charter school, or that the state appointed every board member.
That's true. I agree.
Which is what LeBron tells us is like the relevant inquiry, right?
But in Peltier, the government had indicated that that the schools were deemed to be public. These were created by a statute under North Carolina law, or authorized by a statute, and there were many of the other factors that would say, yes, I agree that there's no evidence or allegation in there that any of the board members were appointed by state. However, I would note that in the Pitt County case, and also the Williamsburg case, the hospital cases, in both of those cases, there was extensive government involvement in appointing the members. And in fact, in one of them, and I believe it was the Williamsburg case, although I may be conflating them, there were governmental officials who served as ex officios on the board. And that still wasn't good enough to constitute sufficient level of government control under the circumstances. And in this case, there's no evidence or allegation that the GRTC board members are anything other than private citizens who are appointed by the shareholders. And in this case, the shareholders are governmental entities. And that's another thing that's critical in this case, is that under Virginia law, the Virginia Supreme Court, as we point out, has ruled that, and I mean, it's not particularly surprising, but under Virginia law, a corporation is not, the shareholders are not automatically deemed to be the corporation, and vice versa. So the fact that government owns the shares does not automatically transfer everything that the corporation does, or the corporation itself, into the government, or make it an alter ego of the governmental form. So I hope I've tried to answer those particular concerns on this. It looks like I'm running out of time on this particular point. I will reserve, I've reserved some time, and I hope I can have an opportunity during that time to respond to the main crux of Mr. Strugar's argument, which is essentially the First Amendment component of the case. But it's our position that GRTC does not satisfy the test for state action under 1983, even if LeBron applies, which we suggested does not. So on that, I will turn it over to Mr. Strugar.
All right. Thank you, Mr. Hill. Mr. Strugar.
It please the court, Matthew Strugar for the White Coat Waste Project. This case asks whether an entity created, owned, and controlled by government can enact a speech restriction with rules so lacking in criteria that the exact same speech can either be permitted or censored based on the speaker's identity. And the appeal raises three issues, only one of which we've talked about so far. First, obviously, is whether GRTC is a state actor. We say yes. The district court said yes. GRTC obviously says no. Then the other two questions are whether GRTC violated White Coat Waste's First and 14th Amendment rights by refusing to run White Coat's ad. The district court said yes. We say yes. GRTC obviously says no. And the third question is whether GRTC's advertising prohibition on political advertising is facially unconstitutional. There, the district court said it is facially constitutional. That's GRTC's position. We say it's facially unconstitutional. As to state action, GRTC is a public transit operator created by the city of Richmond, controlled by Richmond and Chesterfield County, where city funds make up all of GRTC's operating shortfalls, where the city and counties approve GRTC's fares and its routes, and where government actors at all levels view and treat GRTC as if it is a state actor. It's operated like any other municipal transit system. The only difference is it's incorporated. And the record shows there's only one reason it was ever incorporated. It was to get around Virginia's state prohibition on recognizing public sector unions while still getting federal money that required recognition of those collective bargaining rights. The state essentially gave Richmond an exemption to the state prohibition by allowing GRTC to incorporate, and it worked. GRTC's employees remain unionized. The federal government, the Department of Transportation recognized GRTC as, quote, a public body, which was necessary for distributing federal funds. Now, the district court found GRTC was a state actor under two tests. We talked a little bit about LeBron, but its primary, or its at least first basis was pervasive entwinement. And the district court found that 8 factors showed GRTC's entwinement with government actors. The city and county owns and always has owned all of GRTC shares. The city and county appoints its entire board. GRTC uses public use license plates that are used for government-owned vehicles. GRTC is subject to the Virginia FOIA. GRTC is represented by the Richmond City Attorney's Office. The city must approve its fares increases or decreases. The city funds its perennial losses. And its creation was specifically authorized by the Virginia legislature. Judge Richardson, talked a little bit about in LeBron how it was authorized by, how the creation of GRTC was authorized by Richmond, but it was actually authorized by both the state and the city. Because of the Dillon rule, the state had to give specific authorization to Richmond. It passed a law that did not apply to any other actor, did not apply to any other city. It was, I hesitate to use the word special, but it was specific to Richmond buying a public transportation system that was previously privatized and falling apart. And it gave Richmond that specific authority, which then Richmond took and created it. But returning to entwinement, that's pervasive entwinement under Supreme Court precedent. In Brentwood, a private athletic association whose membership was 84% public institutions, mostly funded by state actors, was pervasively entwined enough to the point to becoming a state actor itself. And Brentwood asks 2 questions that I think are relevant here. First, it says, given the entwinement, is there an offsetting reason to see the entity as private? There wasn't in Brentwood, and there's not here. Again, the sole reason for incorporation was to tap federal funds while getting around the prohibition on public sector unions. But that's not a reason to exempt it from the Constitution. There's no unfairness in finding state action here. The second question Brentwood asks is, how does government itself view and treat this entity? Do they view and treat it as part of government? And here, government actors at all levels view and treat GRTC as a state actor. It's represented by the city attorney's office. It's subject to the Virginia FOIA. It uses public use license plate for government-owned vehicles. The Federal Department of Transportation considers it a public body for federal transportation money. So because GRTC is even more intertwined with government actors than the Athletic Association in Brentwood, precedent compels finding GRTC is a state actor for the purposes of Section 1983. But on the alternative holding, the district court found that under LeBron, government created and controlled corporations are the government for the purposes of state action. Here it was created by government. The Virginia Assembly passed a law with a single purpose to give Richmond the power to incorporate the entity. Richmond then incorporated it. If government didn't create GRTC, no one did. And then it's controlled by government. It was enough in LeBron that government appointed all of Amtrak's board. That's what we have here. And while Amtrak at least had some common stock owned by private individuals that at one time had voting rights for the board, GRTC stock always is and always has been exclusively owned by Richmond and Chesterfield County. There's more control here than in LeBron. Brentwood summarized LeBron's holding by saying Amtrak was government for constitutional purposes, regardless of its designation as private, because it was organized under federal law to obtain government objectives and was directed and controlled by federal appointees. We have each of those elements: organized under state and city law to obtain city objectives and directed and controlled by city and county appointees. As to just a couple of points on the authority that Mr. Hill was discussing, I think the easiest way I think Phillips is actually easier than Mr. Hill, Your Honors, were wrestling with. In Phillips, the state was presumably incorporated by the locality or at the insistence of the locality, but that was in the 1950s. The difference in Phillips was that it was sold in 1998. So even if it was created by this law, the North Carolina Hospitals Act or whatever it was, yeah, perhaps it was a government created and controlled corporation from the 1950s to 1998, but it was sold for $30 million to a private actor in a deal whose contract said the purpose was to make it a private entity. So after 1998, when the Phillips case came up, it was no longer sort of created. I mean, it might have been created at one time, but in its current form, it wasn't created by any special law. It was created by being sold, by being privatized. Now there's some question in this case about whether government actors had to come in and sort of direct GRTC to deny my client's ad. The case law doesn't require anything like that. In LeBron, there was no evidence or argument that government actors, federal actors came in and said, hey, reject this specific ad. It was enough that there was an advertising policy appointed by the board. And LeBron talks about Amtrak being a state actor sort of per se, and there's a dissent. It's an 8-1 decision. Justice O'Connor's dissent says, hey, we should look at this act by act. No, not a per se rule that an entity is a state actor for all purposes. But that's GRTC's position here, but that got one vote in LeBron, and the 8 votes went the other way, saying it was per se. I recognize that some of this court's decisions, including Peltier, sort of look act by act. But even in Peltier, the court looked to the board making the dress code policy, not the teacher sending the student home pursuant to the dress code policy. Here, GRTC asked for a rule that the government would have to compel the teacher to send the student home instead of just enacting a policy or enforcing a policy that exists. Here, the GRTC's board, appointed entirely by the city of Richmond, enacted the advertising policy, and it was that policy that controlled here. If I can move on to the First Amendment argument, because GRTC is a government actor, it must comply with the Constitution, and we contend that it's both GRTC's political ad prohibition is facially unconstitutional for 2 reasons. It's incapable of reasoned application, and it's viewpoint discriminatory under the First Amendment. And for similar reasons, it also violates the 14th Amendment because it's vague. GRTC rejected my client's ad criticizing experiments on dogs at the McGuire VA MC pursuant to an arbitrary exercise of discretion. GRTC's, like the Minnesota Voters Alliance versus Mansky, GRTC's prohibition on political ads offers no sensible basis for what can come in versus what stay out. And both Mansky in this case involve non-public forums with virtually identical prohibitions on so-called political speech. And the cases applying Mansky to political speech prohibitions in non-public forums since post-Mansky are unanimous, except the case out of the Third Circuit, the suburban mobility case out of the Sixth Circuit, the Zuckerman and AFDI cases out of the DC Circuit. Each struck down a prohibition on vaguely defined political speech in non-public forums, and they struck them down facially. And the record here is clear that there's no reasoned application. GRTC's ad allows in one ad opposing animal cruelty in the context of spaying and neutering and dogfighting, while censoring my client's ad in the context of animal experimentation. It'll run ads about the vice presidential debate, despite the obvious political nature of presidential elections.
I think the analogy is not quite that close as you say. I think the decision here was a suggestion that there was a political debate on an issue, and they don't want to take one side of the debate. And the ad that you have here is Stop Taxpayer-Funded Drug Experiments. That's the ad. And Ms. Pace determined that it was put out by a political action group. And because that is controversial as to whether it takes a public position on stop taxpayer funded ads, she concluded it was a political ad. It seems to me that's a lot closer than prevent cruelty to animals, which is sort of just a moral proposition that most people would support. I mean, if the ad on the side were take any hot issue and the ad was put on the side supporting one side of the hot issue, the school bus company could clearly say, it looks like we're sponsoring, at least we approve these ads and it'll be attributable to us, and we don't want to get involved in that and distracts from our neutral public service. So I'm not sure it's quite, and I'm not sure the Mansky case is quite analogous. It applied some of the same principles, but there, each person coming into the polling place would be speaking by reason of a T-shirt or a badge, and could say it's just a whole range of things. And as you know, Justice Scalia came up with all different types of possibilities, what's included, what's not. But here we have an ad put on the side of a bus that's been pre-approved and you have to pay for, and people would attribute it to the bus company. So I wonder why this isn't closer to the Lehman case.
Sure, I think, well, let me start with the post-Mansky precedent. Both, each the SEPTA, Suburban Mobility, Zuckerman and AFDI found that Lehman didn't control, and that ads on, I think in each of those cases, arguably more controversial than my client's cases, were still sort of so amorphous in what could stay in and stay out that that they didn't survive. So, as to Lehman, the first, if I could just pull it up, the first sentence in Lehman frames the issue as whether the bus agency had to accept paid political advertising on behalf of a candidate for public office. So you had a much more narrow and defined prohibition in Lehman than you did here. A speaker could know coming in whether it could stay in or stay out.
But the prohibition was political advertising. The ad in that case happened to be promoting a particular candidate. But the question is, does a political ad, is it limited to a particular candidate? And I thought that the company here suggested, well, there are political issues, hot political issues. I mean, what if somebody came in and said, ban all abortions? And sure. You put those on the buses throughout the city. You'd have people throwing eggs at it and drawing graffiti on it and distracted, and they would assume the city is taking a political position. And I think the city could say, well, that's a hot issue, that's debatable, and there's a political action group put it on. I think that was important to Ms. Pace's analysis as to whether there was a political action group behind it. But in this case, she concluded, number one, it was stop taxpayer-funded dog experiments, which is talking about spending taxpayer money and an issue on that. And the second thing she said, she checked to see it was a political action group and found that it was, and thought that that is sufficiently controversial to constitute a political ad. I think under layman, the question is whether that's arbitrary and unreasonable, and it's a hard case to make.
I don't think so, Your Honor. I mean, I think that the Ms. Pace's application of political ad prohibition shows some of its problems with her conception of what is a political action group or a political action individual. She would allow.
You can say that if you're making a facial argument, and that's a whole different standard. But if you're not making a facial argument, it seems to me you have to focus on the facts of this decision.
Sure. Our cross appeal is the facial issue. So we're
I
making
understand that. I understand that.
And you know, Ms. Pace said, you know, support the troops could come in depending on who, you know, decide who is speaking. You know, whether they could run Nike's ad featuring Colin Kaepernick's face would require GRTC to research him and what his views are. Whether Walmart can advertise depends on what they say about them on their About Us. As in Mansky, whether an ad is prohibited or not turns entirely on the background knowledge and media consumption of the official applying the policy. As to, you know, the risks GRTC would have to put up, you know, any kind of inflammatory advertisement. I think there's numerous ways to deal. There's numerous limiting principles. There are, you know, GRTC prohibitions.
Sure, that you can do better. The question is whether this one is defective. And I noticed that when citizens designed their own vanity license plates and put them on license plates, the Supreme Court suggested that that was imputable because of the approval process to the state. And actually in that case, the Walker case, they called it government speech and therefore wasn't even under the implicating the First Amendment. This is clearly, that case said layman is not a government speech case, but it still is at that end of the spectrum where what's on the side of the bus is imputable to the city of Richmond and Chesterfield County. And they just don't want to get mixed up in controversies because transportation is supposed to be neutral for everybody. And if somebody's getting on the bus and sees the ad there, inside or out, it could cause conflict, tension.
Yeah, if I may respond just really quickly with a couple of points. First, there's nothing in the record suggesting that anybody would have, that they thought that anybody would have reacted adversely or violently to my client's ad in particular. And that might be a reason to keep out inflammatory ads in general. There's many ways GRTC could address that problem.
Well, taxpayer-funded dog experiments. That sounds pretty controversial. I don't know who's doing taxpayer-funded, and there must be an issue on that. But it's but it was a political action group's position,
maybe
anyway,
simpler.
I made my point. I didn't mean to. I mean, I understand your position.
Maybe the simpler answer is a ban on controversial speech is viewpoint discriminatory, and viewpoint discrimination is not allowed in non-public forums. There are numerous ways GRTC could keep out ads that would actually cause disruption. There are prohibitions that we have not challenged here, including ones that subject groups to scorn or ridicule, prohibitions against the advertising that promotes antisocial behavior. There might be others. Those kind of ads could be screened out there. Other courts have found that ads that there is an actual record that they are likely to cause violence, including ads about the Middle East and Israeli-Palestine conflict, can be screened out. That's the Ninth Circuit in Seattle Mideast Awareness Campaign versus King County. They could deal with this the way most major cities deal with this, New York, LA, DC, and that they simply prohibit non-commercial advertising. Every advertising has to propose a commercial transaction. That screens out a lot of the sort of ads criticism of Islam.
If you look at the list that the city has here, you know, They don't want political ads, but they also don't want religious ads. They don't want, there's a list of what, 10 or 15 areas they don't want, and all saying just what you're suggesting. I mean, what they don't want is controversy on the public buses. But,
well, sure,
anyway.
but they allow in all kinds of non-commercial advertising, as you know, as we showed at that thing, sort of the Gracie's Guardian, or even the Support Our Troops advertisement that they would allow if it was the federal government speaking, but not if it was a veterans' rights organization. And finally, it could meet strict scrutiny. That's essentially what the Ninth Circuit found about the Israel-Palestine ad in the Ninth Circuit, was that they built a record that it was actually going to cause violence, and it was essentially a strict scrutiny decision. So I see my time is up. Just in summary, any GRTC's advertising prohibition does act as a prohibition against advertising that GRTC believes will be controversial, and any prohibition on controversial speech is inherently viewpoint discriminatory on its face. And for that reason, we ask that the court affirm on state action and the as applied rulings and reverse on the facial constitutionality.
Thank you, Mr. Sugar. Mr. Hill?
Thank you, Your Honor. And I don't really have much to add to the colloquy that was just had there, other than to just note that, as Judge Niemeyer has indicated, this case is governed by the Lehman case.
Well, let me ask you about Lehman. It says governed by Lehman. But Lehman was very clear there. It says, and I'm quoting, there was uncontradicted testimony at the trial that during the whole 26 years of public operation, Shaker Heights system, pursuant to the city council action, had not accepted or permitted any political or public issue advertising on its vehicles. That was a very driving factor of that case. The very fact, matter of fact, the opening statements of the opinion itself talked about, that's the narrow question. That's not the facts here. You have to rise or fall on this record here. You got an extensive discovery record here. For example, that is, you were not only looking at what was to be written on the advertisement, you were trying to find out who was saying it. That's kind of the height of viewpoint discrimination, isn't it? Let's see, wait a minute, we see what their ad is, but let's see who the person is and what they think. Isn't it true that you go and look at their website to see whether or not they're going to pass muster, notwithstanding you've read the four corners of the proposed ad? Is that correct?
Your Honor, I think that that there was testimony about that during the hypotheticals that were presented.
They were not hypotheticals. These were actual instances where she indicated they actually went on these websites and actually went around the office and procured the other views of other people in the office, correct? There was nothing, isn't that right? Isn't that the record that she actually went to see who, and if a person turned out to be an advocate, whatever that means, then that would mean no ad, notwithstanding what it said.
Well, I think that if the ad was, the testimony is that there had to be a determination made to avoid all of the issues that I think Judge Niemeyer had indicated. And one of those is trying to avoid controversy. And
how do you avoid controversy by deciding who's saying it? That is the ultimate of contrary to the American way. You're saying that if John Doe, who I liked, is saying this message, okay. But if I find that Jane Doe or whomever, let's say somebody else, or Betty X or whomever says it, same thing, but I find out after looking at her webpage that she's a person, a persona non grata or whatever, or maybe a lightning rod, then they don't get the ad. That sweep is exactly what the case law says. The law lacks any plainly legitimate sweep. That's the other side of facial ineffectiveness, beyond just whether or not any particular circumstance could be valid. Isn't that is the two sides? Isn't this sweep incredible? Then we go and find out, we do a search on you. We do a search on to see whether or not your ad is permitted. What could be broader in terms of viewpoint discrimination than that?
Well, Your Honor, I would note that under Lehman, the Supreme Court in that case specifically indicated that the pamphleteer would be prohibited as well, and that they endorsed the concept that buses wanted to endorse not just the narrow advertising by identified political candidates, but any issue-based advocacy. And I don't know how you determine whether something is an issue-based advocacy without trying to determine that. And
no, it didn't. It said that they have 26 years, they had never accepted any, and that's any political or public issue advertising on its vehicles. That's what you can. It's amazing how people take cases and then expand them way beyond the facts. That's what drove the facts here. In this case, that is because, but here, this case here on its record, it says that you went beyond just whether it was political. You determined based on who is speaking, gave information as to whether or not it's permitted. What could be broader than that?
Well, Your Honor, I think that discussion was had in the context of presenting hypotheticals during the depositions in which.
Well, I think that was not a. Go ahead, Judge Niemeyer. Go ahead. Go ahead. Go ahead, Judge Niemeyer.
Yeah, I thought the testimony was that in order to determine whether speech was controversial, whether it was political, was a public debate on it. She checked to see whether it was a political action committee, and it wasn't because they were political action, but that was intended to be evidence of a political message. In other words, she was trying to find out if this is part of the public debate that has another side to it and could be controversial. I'm not. That's what I thought the record showed in this case, but I may be wrong on that.
I agree with that. I think that's a fair characterization of what was said. And
so you mean so the inquiry was to see whether or not someone disagreed with it?
Well, the first step in the process is that the advertisements have to be submitted. And there was lengthy discussion at depositions about hypothetical ads, none of which had ever been submitted, many of them which had never been submitted. The discussion was being done in the vacuum of the high pressure of the deposition without the discussion and back and forth that potentially would have been had with respect to any of the ads. And so, while I understand the general point, the Lehman endorses a rule with respect to these types of decisions and these types of forum that it has to not be arbitrary, capricious, or invidious. There's certainly no evidence that occurred with respect to the plaintiff's ad. And if discretion means anything, I think it has to allow the authority to make close calls. And, obviously there may be some situations in which that close call would be resolved in a way that this court may not agree with, or others.
Mr. Hill, what about this? Is it true that the record says that it was proposed that perhaps if they partner with another group, a message could be given, correct?
I believe the specific testimony is that if they partnered with a governmental, it could be considered a public service message. And let me just note on that.
Governmental? I mean, wasn't another group protecting animals? Was that governmental?
My recollection of the testimony, Your Honor, is that the specific context of that question was if they had partnered with a governmental organization, that it could be considered as a public issue or public advocacy type of ad in the context of a governmental. And I would note that
government speech.
Well,
government speech is not subject to First Amendment scrutiny.
That's correct, Your Honor. And I mean,
again, if they partner with the government, then that's, oh my goodness, they're saying that, okay, you can speak as long as you get the government to join you. Well, my goodness, that's the most antithetical statement I can think of about American way in terms of our Constitution.
Your Honor, I appreciate the point, but I would note, as Judge Niemeyer indicated, that I'm not
debating with Judge Niemeyer. I'm talking to you. Well, you're saying that represents the First Amendment analysis to say, oh, you can do this if you get the government to agree. I know a lot of authoritarian, totalitarian governments around the world might be embracing our Constitution if it's read to mean that.
Your Honor, I would note that if assuming that GRTC is a governmental actor, and of course we don't concede that that's a big issue in this case. However, if that were the case, government speech is not covered by the First Amendment. Government can run its own speech and government can prefer its own speech.
That's not the point. The point is we're trying to interpret your restriction on advertising. And it's not whether or not, we know the government is different, but you say in part of the way you do this, you told them, perhaps if you join, this is your words, with the government, a government entity, you could put the same thing on there, or what? What would have to alter it, or what?
Again, Your Honor, I think the discussion was, the context was, if you work with a governmental agency or entity, perhaps we would consider running it as a something that would constitute essentially a government speech advocacy on their behalf, and that's permissible.
That's
the government to prefer its own speech.
So you don't think that would be the law would like any plainly or legitimate sweep there? You think that's a legitimate sweep to say, well, we can call you out if you don't have the government's imprimatur, and if you do have it, you can have an ad?
I think that the question is whether or not there are delineable standards. And if you're asking me whether or not that is a delineable standard, I would say that it is. If the question is, if you partner with a government agency to advocate on behalf of a action or activity that you work with that agency on, that's going to be allowed. Whereas if it's something that that's controversial or political, you can't do it on your own. That is a delineable, clear standard that satisfies the non-public forum requirements of Lehman and all of the cases that have been discussed.
I thought they didn't want any controversy. So you're telling me that there's no controversy when the government joins your view? I think a lot of views of the government, that's what changed a lot of the things. I mean, we had in terms of, enslavement of people and all kinds of atrocities in our countries because people spoke up against government practice. And that's how we got eventually change. But you're saying that that's a proper First Amendment sweep to say that if you can encourage the government to join you, then that's the way it operated. That's far from Lehman. Far from Lehman.
I respectfully disagree, Your Honor. I
understand that you may respectfully disagree, but reading the case, you're nowhere near that. It's because they had been true to the sense of all of them. It's no question they could ban every political ad. Period. That's what Lehman stands for. You could. But you can't just take it and say, well, viewpoint here, and we do that, and we'll decide that, because there's no way, as the district court found, any reasonable person would understand what the restriction is.
Again, Your Honor, I don't think that that's what happened here. And the evidence being presented as hypotheticals, the vast majority of those are not real world examples of ads that were ever presented and vetted and discussed. And, it was an offhanded comment that was made during the deposition, and whether or not what practical effect it would have, it's hard to tell without working the process from beginning to end. I think that the larger point is that government speech is government speech, and it's simply not. The First Amendment doesn't apply to government speech in this context, and so it's in some ways, I would argue, a red herring to try to delineate that out from the larger issues that are going on. So on that, Judge, I see I am way, way, way beyond my time, and I certainly appreciate it, and I appreciate seeing Mr. Strugar again.
All right. Mr. Strugar, you have some time reserved.
3 points, if I may, Your Honors. First, on the government speech issue, it was never raised below, and GRTC has waived it, presumably because GRTC does not believe it is part of the government. It's also not how the doctrine works. When GRTC runs an ad for McDonald's, it's not Richmond or GRTC telling people, yay, McDonald's. It's an advertisement. finding government speech in an advertising forum would
But
destroy
you
the
know,
doctrine.
I think what you say is pretty true, but we try to figure out where the jurisprudence is on this, and we have the Walker case where an individual designs his own license plate. It's his own speech, and the government approves it and puts it on the license plate. And the Supreme Court says that's government speech.
Sure, and that's because the whole forum is a government speech forum. This came up in the argument.
It's on the license plate and it's for display. Everybody knows it's a government license plate, but it's got the individual who's driving the vehicle speech. And so here we have a government bus, and everybody knows it's a government bus, but the advertisement had to be approved by the government. And clearly, it's private speech because it's an ad. That's people assume. They're not perfectly analogous, but I must say these things aren't all crystal clear.
Sure, I think in some ways you're conflating two parts of the license plate. In Walker, they weren't dealing with the actual numbers on the plate that are sometimes vanity, that are the individual drivers or licensees' speech. They were dealing with the sort of background, the frame, how that all works. And they said, that was the government speaking. This came up a good bit in one of the Third Circuit cases recently, an argument. Judge Hardiman, made the point that in all the government speech cases, those forums were never open. So if you have a forum that, and sometimes the government can say, oh, now it's us speaking, but other times, hey, it's just the private individual speaking, and the viewer doesn't know whether it's on or off, that would destroy the doctrine, because at that point, the government could just allow in stuff that it likes. Progressives could rally in Monroe Park because the city of Richmond is progressive, but prevent the Tea Party from rallying there.
Yeah, but the government's explained that's the difference between a non-public forum and a public forum. And the non-public forum, the government can exclude and does exclude, as long as it's not arbitrary, capricious, and invidious. So
sure,
it's a different standard altogether when we're talking about putting ads on the side of a public bus. Now, I know whether it's a public bus is another issue. It seems to me
that in government speech doctrine, there's no forum at all. It's not that it's non-public forum. There's just no forum. Here we have a non-public forum that's been conceded by all parties. So if I could just get back to Lehman for one moment. I know I'm over my time, but again, Lehman dealt with a precisely defined prohibition that if we had here, white coats ad could have come in. GRTC interprets political to mean anything that deviates from the status quo, and that was the problem with Mansky, and that's the problem with post-circuit Mansky circuit cases. And that's how the circuits reconcile Lehman and Mansky, especially Center for Investigative Reporting in the Third Circuit and the Zuckerman case out of the DC Circuit. They said basically, if you have a narrowly defined and understood definition of what political means, that can be implemented in a non-public form. But these indeterminate prohibitions cannot. Second, as to the arbitrary, capricious, and invidious, Lehman just applies a different test than the test that's applicable to non-public forums today. Lehman predated public forum analysis, which was developed in the 80s. It's a case from 1975. The modern test for reasonableness, which Mansky defines, is whether it's guided by objective and workable standards. Lehman has a much lower bar for state actors to clear. The invidiousness, capriciousness, and arbitrariness standard is just much easier for government than the modern test in non-public forums. So for those reasons, we ask the court to affirm the district court on the state action and as applied rulings, and to reverse the district court on the facial validity of the statute. Thank you.
Mr. Hill, Mr. Struger, thank you so much for this engagement. Let you know that the court appreciates your robust arguments, and thank you so much. And we can't come down and shake your hands, but know that we appreciate your arguments, and well done on both sides. Thank you so much, and be safe and stay well. And,
thank you.
Yes, indeed. And with that, we'll ask the deputy to adjourn the court, at least for this session.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you.
I gather we're in a roving room.